But under compelling circumstances, my lord, I am mentioning one matter before your lordship. My lord, show cause notice has been given by the subdivisional controller. My lord, the second show cause notice without hearing first show cause notice, I file reply without anything. My lord, deciding second show cause notice has been issued and 7 days has been given to my lord made reply. Otherwise, my license will be cancelled. My lord, kindly any date as your lordship inconvenience, I sub notice to the state authority and come back.
What is the matter? New matter?
New matter, my lord, on my lord, 103 of your lordship's list, today's list.
Today's list?
Yes.
Then how you mention, not mention yesterday?
My lord, yesterday, my lord, I.
Yesterday,
Yes, yes, my lord, I. This,
if you mention yesterday, that matter
yes,
appear
yes.
tomorrow.
Yes, my lord, I know, I know. My lord, any date as your lordship in convenience, my lord, I'll sub notice to the
Item
state
number
of
103
and 106.
both the matter.
Both the
Same
matter.
issue.
Same issue, my lord, two different, my lord, dealer. My lord, 106, my lord, my learned friend appearing for the state. He is appearing.
103
and 106.
103 and 106.
Yes.
This is a motion matter.
Motion matter. Well, newly filed.
It can be taken up today also. If not today, it
Yes.
would appear Monday.
Monday.
It would appear on Monday under heading mention matters.
Grateful man.
If not today or tomorrow, the matter will appear on Monday.
Monday, Monday.
All
I'm only.
you have the instructions.
Yes, I have the instruction.
You have the instructions. Come on Monday then.
Yes.
Okay, I will dispose of those matters. If not today and tomorrow,
Only I need 106 lordship.
103, my lord, I will submit.
both 103 and 106 will appear on Monday under mention matter.
Grateful man. Very great.
Call the list.
In this matter, Mr. Putip Chatterjee appearing for the petitioner, my lord. He is suffering from high fever. Lordship, kindly make it note this week. Pursuant to your lordship direction 23rd of June. That's it. Pursuant to your lordship direction of 23rd of June, I have served the copy upon the learned advocate general. Let it appear on next week, my lord. He is suffering from high fever, my lord. That's
Very
why-
good. Next week, is it be possible for next week?
Yes, let it be taken up on next Monday.
Next week means next Monday. Very well. You are appearing?
State led by Miss Sonasina.
Have you served upon the learned
I have already served upon the learned
advocate general?
Yes, yes.
Okay.
Yep, sir. Pursuant to your lordship.
Not this week.
Not this week, lordship. I am grateful, lordship.
They appear for the petitioner, my lord. David sells to pay the bill. Kitile konto dekho.
Have you received any affidavit?
As usual.
Let it be in the list next week. Not this week.
Lordship will kindly record an order, my lord. Kindly record
Okay.
an order.
In spite of direction of this court, the state authority has not placed the affidavit in opposition. Let the matter appear in the list in the next week under the same heading. Next,
7 of 10.
whether you serve,
No, I'm not there.
you are not in this matter.
Ki naam कैसे है? No, ऐसे कैसे?
Not today.
But item number 6, my lord, I see the affidavit service is in the file.
What?
The affidavit in item number 6.
6?
Yes. Let it be kept in the record.
What is this?
The affidavit of service.
Okay. 6 लिखे नहीं तो affidavit of service filed on behalf of the petitioner is taken on record.
Although my lord, state had appeared on the last occasion.
Next.
Lordship, landed advocate Roger Dutta just coming, Lordship, whatever direction is complete, Lordship. Kindly, I am praying for possible, Lordship.
Who is for the petitioner?
I appear for the petitioner. my lord.
For the petitioner. So what are you saying? Affidavit in opposition ready?
Lordship,
No,
Lordship.
they have served the report
Sir,
yesterday.
give me the affidavit in opposition.
Clark, he is a handler. I'm pretty much just short possible, Lordship. I'm praying for just short of possible, Lordship. Within few minutes, he'll come, but
Mr. Huda, whether you use the
Just
reply.
no, perhaps my lord, some more directions would be required. I'll just show 2 documents. Let Mr. Dotto come, my lord.
Lordship.
It's better, my lord.
Pass it over for a while.
Respectfully. And I appear for the petitioner. But ये गलत था ना? Hostile. ये actual order. It's not convenience. But in this, my lord,
Where is the application for amendment?
no, Lordship had allowed, my lord, the
Okay.
yes, but this is the affidavit of service. If served after amendment, my lord. Shapun Kumar Dotto was appearing for the state, my lord. In fact, he had said on the last occasion, it's just a formality. It's one of those matters, my lord, where I have challenged, my lord, the vacancy notice issued under 2024 notification. My lord, this is the, my lord, ample on.
Have you served upon the amended persons?
Yes, yes. I have filed this affidavit of service.
A detailed report from the state.
Yes.
Please take down. Affidavit of
No, Mr. Dotto, no.
So sorry, my lord.
तो वही usual order टी सर्विस होएगा ना जो ये पोस्टरली भूल ছিল
हाँ
सर्विस করে দিয়েছি usual order टी
जो लगा ना
जो डिटेल रिपोर्ट देता কোনো ये नहीं तेरी मॉडल
इतना नहीं तो डिटेल रिपोर्ट चाहिए
similar orders.
yes I think what he has
The
told me.
detailed report from the state.
Yes.
Please take down. Affidavit of service filed on behalf of the petitioner be taken on record. Full stop. It appears from the affidavit of service that writ petition was served upon the all respondents, including the respondents whose name was amended by the petitioner. Full stop. A similar direction.
কস্টার্ড অ্যামেন্ডমেন্ট করার ছিল কস্টার্ড
Business. এই নাম্বার তো দেখেন চেঞ্জ হয় আচ্ছা similar direction.
Report content got
Detailed report.
very well.
The state is permitted to file a comprehensive report
Lordship.
in the form of affidavit within 2 weeks. Within 2 weeks from date.
let it be 3 weeks
Okay.
consider your lordship notes
State is permitted to file comprehensive report in the form of affidavit within 3 weeks from date. Exception, stroke reply, if any, by the petitioner within 2 weeks thereafter. Let the matter appear in the list in the second week of August 2025. দেখে নেবো last time.
Second week of August. That's a great to know.
Then, Your Lordship, I appeal for the petitioner, my lord. I have challenged, my lord, the issuance of license in favor of, my lord, the respondent number 6, my lord. But I am told the respondent number 6, my lord, the license has been issued, already issued, my lord. So I will not be praying for any interim orders, my lord.
I could not hear you. What is the, take the mic. Take the mic.
Mr. Arindam Mitra is appearing for the state. I am praying for accommodation on his behalf because he is facing a stomach problem, Lordship, from yesterday's night.
I am for the respondent number 6, my lord. Helps and vacancy. Another unsuccessful candidate filed a petition, and my lord was pleased to pass an order.
Yes, what is this?
Sir, similar direction can be passed.
Helps and vacancy. Another unsuccessful candidate filed a petition challenging the appointment of respondent number 6. And my lord was pleased to pass the order.
Respondent number 6. This respondent number 6.
Interim order can be passed, my lord. I said I am not taking any interim orders now.
There is no scope of
No, there. I'm saying I'm not.
and that's why I am.
Let the state, my lord, come up with a report.
Same issue was, appeal was dismissed for default, same issue.
Same issue, same person.
আমি
But
বলেছি
this
ওরা
petitioner is
মামলা করে
different
নিতে
because
যাচ্ছে।
he is also unsuccessful candidate here who has filed this petition, not only unsuccessful candidate and also the daughter-in-law of the existing license. And the husband of the petitioner is engaged in a Gram Panchayat.
So another issue is there.
Yeah.
So you want the similar direction? Please take down. Who is appearing for the, give me the name.
There are many things which needs to come out of the trunk actually. So there are many things in this matter which needs to come out of the trunk. So let my lord,
Yes.
the state come up with the affidavit, my lord. I actually want to see, my lord, as to how this license could have been issued.
Where is the affidavit of service? Affidavit of service filed on behalf of the petitioner is taken on record. যেমন হচ্ছে একদম similar হচ্ছে। Yes, 21st November 2022. নাকি মেমো যা আছে তাই। State authority is directed to file affidavit in opposition against read petition within 4 weeks from date. Reply exception, if any, by the petitioner within 2 weeks thereafter. Let the matter go out of the list. Party has liberty to mention.
It responds as well as private.
State authority as well as private respondent contractor. Affidavit in opposition. Okay?
Liberty to mention.
But the same.
Liberty to mention.
I appear for this status.
नाम
मैं
क्या बोल
अच्छा
रहा है?
कर-
नाम क्या
मैं-
बोल रहा है? बोल रहा है, नाम क्या?
Rafiqul Hassan.
Yes.
Come on. But this is a 2013, Mullah, the vacancy notification, but the policy decision has been questioned. The curtailment of Mullah, the
Okay,
African
same issue
population.
regarding the challenging the authority of the, no, whether it is the same issue,
I think, my
no
lord,
document is there.
only, my lord,
No, everything is there, my lord. The only, my lord,
the
instruction that we would require from my learned friend, my lord, whether the license has been issued or not, my lord, and as to whether, my lord, the allocation has been made.
uh,
Now, what is your grievance here?
But same 2013 notification of the early order that your lordship had passed.
that is for page 34, P5.
Okay.
So this vacancy notice under 2013 control order. And my
So
lord,
the order of director DDPS. Fixing the population.
Yes.
ration card population, my lord, is being reduced by reason of policy decision of the government, my lord.
Yes.
Well, the same, my lord, which is pending before the division bench, and my lord, there's a step, my lord, passed with the division bench for detagging. Paragraph 10. Affidavit search. I'll be praying for a similar order, my lord.
কোথায় paragraph 10 কোথায়? Paragraph 10. কোন similar order?
Okay, challenge the authority of the director DDPS to issue the same direction to file the report,
Yes.
expensive report in the form of affidavit.
No, my lord. That is 2024. This is 2013, my lord. 2013, my lord, lordship knows, my lord, the issue is pending before the division bench, my lord. And the division bench, my lord, has passed an order of stay, my lord, with regard to detagging. It is that matter, my lord. And I'm not carrying this the sample order with me, my lord, but your lordship knows, my lord. It is sample order.
দাও তাহলে। Yeah, of course, it is 2013 control order, vacancy notification. Page, my lord, I have shown page 34.
Yes.
Division orderটা দাও তাহলে।
Well, this is the order.
Pleading কোথায় আছে?
This is the order of the division bench.
Pleading কোথায় আছে? Pleading কোথায় আছে? মানে কোনো pleading নেই তো এখানে? যে মানে ওই যে ডিভিশন বেঞ্চ যেটা বলেছে সেখানে কোথায় বলেছে?
That is a fact.
After promulgation of NFSA and TDPS, the same issue.
Yes.
Targeted, yes.
If your lordship sees, my lord, paragraph 10 of the order that I have just handed over.
Paragraph 10.
আপনার কাছে নেই।
আমার কাছে তো নেই।
আমার কাছেও নেই। কিছু দিয়ে দিলাম।
Okay, please take down. Affidavit of services filed on behalf of the petitioner is taken on record. Petitioner running FPS business under the license of government of West Bengal over the area. Over a service area wherein the concerned SCFS Balupur has issued a vacancy notification VDA memo number such and such dated 21st of May 2024, page 34. Page 34.
Just hand over.
Okay. It is the contention of the learned counsel for the, no, Mr. Huda, learned counsel appearing on behalf of the petitioner submits that after promulgation of National Food Security Act 2013 and targeted public distribution system within bracket control order 2015, WBPDS maintenance and control order 2013, on the basis of which the notification was published, has become redundant. Full stop. He further submits that. Next paragraph. He further submits that the issue involved in the instant writ petition is also pending before the Honorable Division Bench in MAT 1543 of 2024. He further submits that the Honorable Division Bench, with its order dated 6th of August 2024, has passed an
Same
interim order directing the state authority not to delink any
98301.
DRC from any dealer till the disposal of the appeal.
6083.
Mr. Huda submits that. Full stop. Mr. Huda submits that the petitioner deserves a similar order. Petitioner deserves similar order. Mr. Next para. Mr. Dr. Learned, senior counsel appearing on behalf of the state, raised strong objection and submits that the issue involved in the writ petition may be similar to that of the appeal pending before the Learned Division Bench, but the petitioner, but the concerned director DTPS has the authority to issue the vacancy notification. Having heard the learned counsel for the party, it appears that the issue involved in the writ petition is similar to that of the issue pending before the Honorable Division Bench in MAT 1543 of 2024. Considering the same, the state authority is directed to file affidavit in opposition within 3 weeks from date. Reply stock. Exception if any by the petitioner within 2 weeks thereafter. Full stop. Having considered the facts and circumstances of this case, the authority concerned may proceed with the selection process, but so far as issuance of license is concerned, the same shall not be granted to any person till the disposal of the appeal pending before the Honorable Division Bench, being MAT 1543 of 2024. Full stop. Let the matter go out of the list, particularly.
May I, my lord, very humbly say this, my lord. I was, my lord, humbly praying for, my lord, order in terms of para 10, my lord, D-tagging. If that can be added, my lord.
If license is not granted, that is the order.
So the license is not granted or not granted, my lord, that Mr. Doctor is not in a position to say.
I do not know.
Yes, that is what I'm saying, my lord. If paragraph 10, my lord, it protects me. Paragraph 10 of the order, my lord. Like, my lord, like
Paragraph 10 of the Division Bench.
Division Bench order.
That
Whether that fact situation is there.
I pass the order regarding granting of license.
yes, correct. But in this case, my lord, in every case, my lord, I come and say, my lord, that license has not been granted. And Lordship
But
passes
in
that.
this case, what you are saying,
I am not sure.
then you are not sure whether
Whether
The license has been
the
granted or
court
not.
cannot be invited to pass an order on
No.
on
I
some
am,
unsure.
it is for the state, my lord, to come and answer. The state is not in a position to answer this, and the state blames the
But you
petitioner.
say that it is
you are the petitioner.
pardon,
sir.
yes, it is pardon
No,
on
It
him
is
at the
the
threshold.
state, my lord, to answer whether the license has been issued or
If
not.
there is such a
The Lordship has, my
he
lord,
can come with an order.
Lordship
He
has
can
also
come with
passed,
an
my lord,
application in
Lordship
that
has also passed in Tayyab Ali Mia, my
If
lord.
not, license is granted.
No, in Tayyab Ali Mia also, my lord, Lordship had passed, my lord, similar order, but in terms of paragraph 10. I have the order, I just have the interim order, my lord, of that. Lordship has specifically said paragraph 10.
And but in this petition there is no averment as such. কোথায় averment কোথায় তোমার এখানে?
Main order the madam nikali nahi,
Similar order. 1543 just similar order করেছো, not to grant license. If license not granted yet.
Very well, my as well as we
If
did that.
license was granted, whether we do not know whether the recent commodity is supplying or
That
not,
yes.
that is the
And there is no
you
averment
have
in
to
the
come with a proper order, proper observation that
he can come with
whether
an
it is there.
application, then you
Otherwise,
must
the
pass that
order
order.
is stated. You know, if license is not granted,
The reason why, my lord, writ petitions are served in advance so that the state can come with instructions. Not that when the matter appears on the day that the state will say that we'll come back with instructions.
No, but then
That is, my lord,
then where is
supposed
the
to be-
averment? There is
Otherwise,
no
my lord,
averment in the writ petition itself. Let him say
Otherwise,
particular
my lord, there
averment.
is
then
no
you
pur-
say that
there is no
license was
purpose.
granted, but
No, burden is
such.
on him. He is the petitioner. Burden is on him.
It is not my prerogative in the sense that the license will not be issued in my name. Had I been privy to this, whether license is not issued or not issued, I cannot be privy to this information. this information would only be with the state and the person who is being issued with the license.
Very good. Yes, come next. Who is for the petitioner?
They have a belated claim, probably they have understood that it should not be pursued with. ও পিটিশনে কেন জানেই না কত মামলা ও? Well, may I start till my learned friend finds his brief, Mullah?
And may I file the affidavit, sir?
Yes. What is the matter?
Chief, but the matter is very
Your
simple.
prayer is for making necessary correction
Yes,
in the Gram Panchayat.
yes.
What does it mean?
Chief kindly takes up my representation. Because this Gram Panchayat, the vis-a-vis, page 17.
Yes.
Kindly turns over to page 18. But my client was informed of his by one of his acquaintances about the vacancy notice, paragraph 13. Upon coming to know of the aforesaid notice, my client obtained a copy thereof for the purpose of applying for the same. But I would have been one of the applicants. However, in as much as the terms of the subject notification, the candidate was required to have a godown cum shop under Bamungachi Gram Panchayat, my client could not apply for his appointment. It is pertinent to mention that my client is otherwise eligible to apply in respect of the subject notification, having fulfilled all the required criteria as mentioned therein, except having a godown at Bamungachi Gram Panchayat. The godown of my client is otherwise in consonance with the notification invoked. Then, notwithstanding the above, inasmuch as my client and some other candidates were of the opinion that the Gram Panchayat mentioned in the subject notice was incorrect and mismatched compared to the details of the vacancy location, my client approached the department and discussed the same with the officers thereat. The officers, however, informed my client that the subject notification had been published after approval from higher authorities, and as such, nothing could be done about the same. Recently, on so and so, my client once again met the officers of the department who admitted before my client that the Gram Panchayat mentioned in the subject vacancy was actually incorrect and the same should have been Chaltaberia Gram Panchayat instead of Bamungachi Panchayat. And in fact, due to such issue, even the department was facing difficulties because the very purpose of the notification of public convenience was getting defeated. The officers of the department further informed my client that without an order from the higher authorities, such correction cannot be effective. Well, if your lordship now comes to the vacancy notice. The vacancy notice, my lord, mentions about the service area, the Moja, my lord, the post office, police station, my lord. All these would not match with Bamungachi. Bamungachi, my lord, Gram Panchayat does not fall under, my lord, these areas or does not, my lord, serve the jurisdiction of these areas. The Gram Panchayat should be Chaltaberia. Otherwise, my lord, the purpose of the purpose of publishing a vacancy notice is convenience of the public at large. The distance between Chaltaberia and Bamungachi is quite a lot. It's more than 2 kilometers.
So what notification says? They want.
Notification says Bamungachi. As per the petitioner, this should have been Chaltaberia.
Why?
Because Bamungachi does not fall under.
Not the Bamungachi. Forget about the Bamungachi. What is the central location? Kamaria, Purva, Garbaria. Yes, central location, Doctor Building, Loskar Para.
All these fall under, my lord. All these fall under Gram Panchayat, Chaltaberia. And
This is
Gram
saying Mauja, Kamaria, 88.
Yes.
Jail number 88.
Correct, my lord. These would fall under Gram Panchayat, Chaltabiri and not Bamungachi. Bamungachi, my lord, is a mismatch compared to, my lord, the other criteria or the other locations.
Let them proceed if they mismatch. So what is your difficulty? It would be mismatch.
So had it been, my lord, Chaltaberia, my lord, which should have been as per the petitioner, my lord, I would have also participated because I have a go down in Chaltaberia, not in Bamun.
Whatever may be your go down there be. When there will be
Then, my
notification,
lord,
you
in that case, the distance.
You will apply.
Then in that case, my lord, the distance is huge. Then in all other matters, when they come and say that it is for the convenience of the public at large, my lord, that the purpose gets defeated.
now it is confidence of the petitioner that
It is
his
convenience of the beneficiaries. The
No.
beneficiary is required to be Kamaria, Gram Panchayat,
No, Gram Panchayat of if you
Mauja Kamaria, jail number 88. There is no,
That is not his case in para 5 and 6. My learned friend may read his para 5 and 6
That is
in the writ petition. He says, since I have a go down somewhere else, the vacancy should be somewhere else. That is his case. So I don't know what he's arguing today. It is pleaded in paragraph 5. I invite my learned friend to read his own pleadings.
My lord, this is somewhat like this. May I explain, my lord? This is somewhat like this. Say, for example, my lord, a vacancy is created, my lord, in the state of West Bengal.
no, if it is mismatch, if it is, I understand, if it is mismatch, that is you are saying Chalta, the Gram Panchayat word should be Bamongachi.
No,
Should be Chaltaberi,
Chaltaberia.
not Bamongachi.
Bamungachi does not match with any other location. All these locations fall under Chaltaberia. Let them file a report, my lord. I'm not even paying.
I will report as a matter of course. I'll argue the matter today. Whether report
I
is
don't
required, that has to
I
be
don't
seen.
mind. I don't let it, everything gets recorded in the order, my lord. If the state says there's no Bamungachi,
What I'll say, he may not preempt.
under all
I'll say
these
what I have
locations
come
will fall under
prepared.
Bamungachi. I have no issues with that.
He need
I
not
have no
preempt what
issues
the
with that,
state
my
will
lord.
say. Once he's done, I'll make
But
submission.
my explanation is, say for example, what a vacancy is created in the state of West Bengal. And my lord, specifically, my lord, the areas I've given, my lord, Calcutta and Dalhousie. Now, my lord, if one of the location is, my lord, say for example, my lord, Bhubaneswar, then Bhubaneswar would be a mismatch compared to all the other locations.
I understand
Here
your
also.
submission.
Yes. Here also, my lord, Bamungachi.
Whether the Mauja,
Yes.
Kamaria, jail number 88 come under Gram Panchayat and
No, it does
ward
not.
Bamongachi.
It does not. As per the petition, it does not. It comes under Chaltaberia.
Show me the list. Show me the list of the Bamongachi Gram Panchayat and the jail numbers within that Gram Panchayat. That would be proper. Otherwise, how can I entertain your submission?
Excuse me, my lord, I'll file a supplementary, my lord, giving, my lord, all the details, my lord.
That's right. Yes.
Malad, kindly takes paragraph 5 of the writ petition, page 3. Kindly take the second sentence. However, Malad has got it, Malad? However, inasmuch as in terms of the subject notification, the candidate was required to have a go down come shop under Bamungachi Gram Panchayat, the petitioner could not apply for his appointment. So, misconception number 1, he thought that the go down should be in Bamungachi. That is his misconception. I'll show whether that no bar is there. Then paragraph 6. It is pertinent to mention that the petitioner is otherwise eligible to apply in respect of the subject notification, having fulfilled all other required criteria as mentioned in except having a go down in Bamungachi Gram Panchayat. The writ petition is based on the fact that my advertisement required a go down in Bamungachi. He did not have a go down in Bamungachi, and that is why he could not apply. And his prayer is that I need to change my location from Bamungachi to Chaltaberia so that his go down, existing go down, can fit into that criteria. It is filed with the understanding that the participant has the right to dictate the terms of the offer. The entire writ petition is premised on this, and the arguments being made is completely different. Now, kindly, Malad, for your lordship's satisfaction, kindly takes, Malad, the vacancy notification once, page 13.
Yes.
Serial number part 1.1. Applicants are invited from an individual permanently residing in Baruipur subdivision. This is the requirement. Anyone in Baruipur subdivision could have applied. Even, Malad, if your lordship takes the other requirement in the next page, part 2, point number 8. There also, Malad, there is no bar that go down outside Bamungachi cannot be offered. Therefore, they completely, my lord, out of a misconception, they have not applied, and now they are trying to make out a case that the vacancy should be in Chalta area, so because this last date of application was 10th August 2024.
Last date of application has over.
10th August 24, 1 year back. Representation made for the first time on 9th June 2025. Now, to cover up that, this entire case is being made out that and if I may add the word, case is being made out at the bar that the vacancy has been declared wrongly. My lord, this is a case, my lord, from the pleadings itself, my lord. It can be discerned that what they wanted, and it is impermissible in law. My lord, perhaps no report is called for, my lord. And my lord, the lordship will kindly not give them liberty to file a supplementary affidavit, because I'll tell you, lordship, why. Because, my lord, they cannot better their case from paragraph 5 and 6. Their go down, by filing a supplementary affidavit, their go down will not move from Chaltaberia to Bamungachi. By filing a supplementary affidavit, the last date of application 10th August will not be extended. Therefore, he cannot better his case which is there. Supplementary affidavit is to supplant the case, not to substitute the case.
Very good. Yes, Mr. Huda.
Let us read, my lord, paragraphs 5 and 6, my lord. But because the submission is, my lord, that a case is being tried to make out from the bar. Let's read paragraph 5 and 6, my lord. My lord, so far as, my lord, part 1, my lord, is concerned, my lord, this says, my lord, application invited from so and so, an individual permanently residing in Badepur. My lord, this does not state about, my lord, the go down, my lord. It states about the residence.
Right.
Let's, my lord, read paragraph 5 together. Upon coming to know of the aforesaid vacancy notice, the petitioner obtained a copy thereof for the purpose of applying for the same as a candidate. However, inasmuch as, in terms of the subject notification, the candidate was required to have a go down, come shop under Bamungachi Gram Panchayat, the petitioner could not apply for the same. It is pertinent to mention that the petitioner is otherwise eligible to apply in respect of the subject notification, having fulfilled all the other criteria except for having a go down. The go down, which the petitioner had arranged, was about to get tenancy, is otherwise in consonance with the stipulations mentioned in memo number so and so. Apart from the petitioner, there are several other candidates who also were eligible to apply but had their go down in Chaltaberia Gram Panchayat. So what I am on, my lord, is I have my go down at Chaltaberia. If the Gram Panchayat, which is a mismatch of, my lord, in vis-a-vis.
No, how today that can be entertained after last date of application? How this can be entertained?
If a thing is wrong since inception, if it's wrong, it's wrong today also.
So why you
The
not
wrong is
challenge this?
continuing.
Why you not challenge this?
The wrong is continuing.
If I allowed to you, so how can be done like that?
I am not saying, my lord, lordship. What I'm saying is, I am in fact, my lord, canvassing the cause of others as well. If others also want to apply, my lord, they can also apply.
Then kindly send it to the PIL bench.
Lord, let me complete my sentence, Lord. I'm sure, my
But
lord.
I think my learned friend knows he is in reply.
No,
He will not make out a case in reply. He is in reply.
no, I am
If he wants to
just
go by
trying
procedure, he
answer
will
the
reply.
queries
No,
raised
Mr.
by my lord.
Huda, just me
I'm just
satisfy.
Speak about
trying to
others, let
answer
it
the
go before the
queries raised by
PIL
my lord.
bench. We'll fight it
That
out
is
before the
it.
PIL bench.
That is it.
No others are before
Very
this
good.
court.
I
There's only
am
one
not-
petitioner.
no,
No,
I
no.
am not
You just
interested.
satisfy that how this petition can be entertained after so many date of last date
For
of
that, my lord,
submission of
for that, my lord,
application. Amendment, everything, if you can want, you can file it before the last date of application.
my lord, what I'm on,
That would be justified.
that would have
Now all procedure has complete and now you are coming
no,
for
my lord,
amendment of
no,
the,
my lord, so far as, my lord, I know, my lord, I don't think, my lord, the license has already been issued, my lord.
not necessary license be issued. Someone must have applied.
No,
Then,
that would have been better. That
no,
would
no,
have been
not
my
better,
lord,
not
had
better.
I, my lord, come earlier. But me, my lord, coming after some time, my lord, does not, my lord, vitiate the entire case.
Enter, we said enter case, enter procedure.
Is there a
You
time-
must have come earlier.
Is there a limitation for this?
Yes, limitation is there. You must have,
But
if
I
you
was
want, if
humble,
you
sir.
want some amendment in a vacancy notification, so
Well,
you must have
I am
appeared
not asking
earlier.
amendment. I am saying that a notification issued by the state has some stipulations which is incorrect. It is for the state, my lord, to correct
Let
the
the
same.
state be do so. They will face the difficulty. Let them do so. What are your problem? Okay, please take down.
I will
Petitioner is a
utilize this order in the other cases where they say that the distance, my lord, is an issue.
Okay. Petitioner is a resident of Baripur subdivision. Full stop. Subdivision controller Baripur had issued a vacancy notification being memo number such and such dated 21st of May 2024. Page 30. 1C. Learned counsel for Mr. Huda, learned counsel for the petitioner submits that the vacancy notification issued by the concerned subdivisional controller is incorrect. He said that he submits that location of vacancy, comma, central location, Mauja and jail number are not matched with Gram Panchayat, Bamungachi. Full stop. The location should be within Gram Panchayat, Chaltaberia. Full stop. Mr. Huda further submits that the petitioner has a complete go down within the Chaltaberia, Gram Panchayat. For that reason, he could not apply for the license. He further submits that the instant writ petition was filed with a prayer for correction of for necessary correction in the said vacancy notification. Mr. Sishanu Bandyopadhyay, learned counsel appearing on behalf of the state, submits that the instant writ petition is infractuous. The petitioner who have a go down within the Chaltaberia Gram Panchayat intend to seeks a mandamus upon the state to amend the vacancy notification so that the petitioner may be accommodated. Full stop. He submits that the respondent authority cannot be directed to accommodate a particular person. Having heard the learned counsel for the parties, it appears that the vacancy notification has disclosed central location to be Dr. Builders Loskor Pada within Kamaria Purbo Gaberia at Mauja and jail number Kamaria -88 within Gram Panchayat Bamungachi under post office Chaltaberia, ES Joynagar, district South 24 Pargana. Full stop. It is the contention of the petitioner that the entire central location come under the Gram Panchayat of Chaltaberia, not within the Bamungachi. Full stop. It appears from the record that the last date of submission of application has already been over on 10th day of August 2024. And some person must have applied for the license. At this juncture, the petitioner at this juncture, this writ petition after last date of submission of application appears to be not tenable. Moreover, it further appears that the petitioner intends to amend the petitioner seeks a mandamus to direct the concerned authority to amend the vacancy notification and to republish the same. Republish the same. That too only to accommodate the petition. Full stop. The petitioner has not demonstrated any reason how the vacancy notification is erroneous. Moreover, he has not placed any list of moujas under Bamungachi Gram Panchayat. Considering the same, I find no justification to entertain the petitioner. According to the writ petition is being meritless, disposed of.
Actually, just add Millard one of my submission, Millard, which is that is ground number 3, Millard. And it is my submission, Millard. Can you recall that and then Millard dismiss? Ground number 3, Millard.
C.
3, ground number 3, Millard. The very purpose of notification public will get defeated due to such mistakes since the beneficiary will have to cover a longer distance than they would have had to cover in case of notification is corrected by mentioning Chalta Bire Gram Panchayat.
But a person who has not applied, can he come up with this grievance today? It is his lookout. Is it his headache? But any submission, anything can be asked to be recorded as a matter of practice. It's an advocate's
I
letter.
understand.
My submission
Look,
is one of the grounds.
What is his locus? Who is he?
Chaltaberia is stated to be the post office. On post office within several moujas.
Submission, kindly recall.
Who
the
is he?
submission. Lordship is
He is no
dismissing.
one.
It's fine. but
He has
kindly
no
recall
locus. He is no one. He is not an
the
applicant.
submission. I may be wrong.
He is
I
no
may be
one.
wrong. I may be wrong. in
Once
fact.
the order is dictated,
I may
this
be wrong,
type of
I may be
practice,
wrong.
I don't know where it's coming from.
Submission.
We have not
So,
heard
Mr.
of.
Huda, thank you.
Lordship will not even record the submission.
I have recorded your submission.
No,
Specific submission.
but
I have to record all the
do not think
grounds
this is the right way of
on your whims.
submitting before the court.
At least this.
He has asked at least 5 questions to the court. I don't know how he can.
Specifically
make
asked
submissions
for the
like-
No,
before the
no,
submission be
that
recorded.
cannot be accommodated. You know, this is the post office you are saying. If one post office if one district is to be located in the
I may be
area,
wrong in law, I may be wrong on facts, but if I have made a
But
submission.
Can this be negotiated with the court? I don't understand the
okay,
submission.
okay,
What the submission?
It cannot be appreciated like this.
okay. I have heard
Grateful.
you. Thank you. Next.
Millard, I beg to appear on behalf of the state. Millard, this is also kind of cutting down the beneficiaries number where we have advertised the Millard for the new FPS. I am arguing on the point that whether curtailment of the same is coming under the definition of the fundamental rights or not.
That is the detailed report required for.
This is another one. And this is, I have argued one, Mr. Huda is also there. I have shown to your lordship, there are 3 judgments of our court. One passed by Justice Vivek Choudhury, one is passed by Justice Sharma, and the other judgment which I have relied upon, APM Industries, whereby it has been held that the one particular person cannot go on to have the benefit all over the state. This has to be equally distributed, just like the license raj has to be stopped. Now here, Millard, on the same point I'm taking, cutting down of the Millard, the number of the beneficiary, whether it is coming within the purview of fundamental right or not. Kindly keeps it up any day, I will argue the same.
No, in the similar matters, I call for the report.
I
Detailed
understand.
report.
I understand. That
Let
is,
the detailed report be appear. Your point be kept open. Detailed report ask for the justification to issue the notice orders by the director DDPS for
Millard,
DRC
this-
population.
I
DRC population.
just indicate 2 things. Lordship knows far better than I do. Article 39B postulate the power to distribution in a economic manner. I just indicate the 39B once more. Lordship is seeking for the report I have, but the genesis of the same, it is coming for the 39B is a directive principle of the state. May I place just for once?
কনস্টিটিউশনটা দাও এই বইটা বের করো ছাড়
এটা বার করতে এখান থেকে EBC-টা বার করতে। May I just indicate? Certain principle of the policy to be followed by the state. The state shall, in particular, direct
you are reading article
Article 39,
article 39
the directive principle of the state towards state shall, in particular, direct its policy towards the securing A. The citizen, men and women, equally have the right to an adequate means to the livelihood. This is number one. Kindly come to the B. That the ownership and the control of the material resources of the community are so distributed as best to serve the common goods. But then beneficiary legislation, Millard, the state also have a right to make a policy decision in the light of the 39B. That the beneficiary legislation has to be extended in every corner of the state. It is not pertinent to one particular person for whom and the wills the card holder will be remain with them. It is not that. It has to be distributed. If I connected two things together, one is the beneficiaries, the number of the beneficiaries, the genesis or the object of this distribution system is that to smooth distribution system at the doorsteps to the beneficiary. This is
why I want the justification from the DDPS. That's why I want the justification from the
economy part and the lordship, the
Yes.
economical viability. Second is the geographical
locations
and
of each and every case.
each and every case. Now,
Yes, within that vacancy notification, there are 5,000. Within some vacancy, there are 3,000. There are 10,000. That is the justification I
correct.
want.
Not some whether lordship is possibly seeking the report
Yes.
in, if I correct Millard, kindly do not take me amiss, whether we are maintaining the same parameter or not. Possibly
That is
this
the-
is falling from your lordship.
In the year 2021, there is a notification from the government
Correct.
maintaining 6,000 to 7,500. Thereafter 2022, thereafter 2023. These
And
are the
if your lordship sees the 9(6) of the PDS order, here also we have a right to regulate the card holders. So once the constitution giving us the power and as well as the statute is giving us the power, in my humble understanding, there is nothing wrong. But I will definitely come up with the report by indicating what is the viability, what is the
Yes.
economic viability,
So I
what
want-
is the geographically. But my respectful submission in that event, since this is a policy decisions,
Yes, I kept it open.
this is
And
very,
cases I kept-
yes, I do.
In all cases, I kept it open.
Yes, very well.
So that the matter can be disposed of.
Because what happened today, lordship knows far better than I do. In the different district, different distributor are there, different numbers of the beneficiaries are there.
In-
Some
In different mojas, there are number of beneficiaries
Correct.
different.
correct. Lordship is absolutely correct.
That's why I want the justification. What
That is why, suppose somebody is having the 5,000, somebody is having the 2,000. Now, if I equate the balance of the same, equilibrium of the balance is also coming in questions. We cannot do that, but we have to maintain a certain parameters. I will come back with the report.
Yes. Yes, Mr. Huda. You are there in this matter? Yes.
এটা তো এখন বলবো না, ওগুলো পরে বলবো। এটা কি আছে দেখি।
Petitioner seeks similar direction.
আমারও বলি
ওই যেটা করেছিল ভুলে গেছো? Detailed report from the state respondent. ভুলে গেছো? হ্যাঁ, বলে দিচ্ছি, ঠিক আছে। বলে দিচ্ছি। Petitioner running APS to a license issued by the respondent authority in a service area wherein the concerned subdivision controller food and supply had issued a vacancy notification wide memo number such and such dated 10th of February 2025, paragraph page 36. Mr. Huda, learned counsel, appearing on behalf of the petitioner, submits that the same notification was issued in pursuance to an order dated 11th February 2022 and 28th March 2023, issued by the Director DDPS. He submits that the Director DDPS, Mr. Huda submits that the Director DDPS had no authority to issue such an order, violating the guideline of the state dated 3rd of September 2021. Full stop. Mr. Suman Senruto, learned counsel, appearing on behalf of the state, submits that the state authority for smooth distribution of ration articles had issued orders through Director DDPS fixing the minimum number of DRC to be retained by an existing FPS dealer. Full stop. It further submits that the state authority is within the domain to issue such an order. Moreover, such order or such order of fixing minimum number of DRC to be retained by an FPS dealer is a policy decision by which fundamental right of the petitioner cannot be infringed. Full stop. Having heard the learned counsel for the parties in considering the matters involved here, it appears that in the similar issues, this court has directed the state authority to submit a detailed report. I think in this matter, the issue cannot be settled without submission of report by the respondent authority. Under the above observation, the state authority directed to submit a detailed report regarding justification of concerned Director DDPS to issue such an order for fixing minimum number of DRC to be retained by existing FPS dealer. Such report shall be placed within 3 weeks from date, from a reply, if any, by the petitioner. within 2 weeks thereafter. Let the matter appear in the list. 3rd week of August 2025 under the same heading. The issue of maintainability raised by the learned counsel for the state be kept open.
My lord. Deeply obliged. my lord.
Affidavit certification.
14, my lord, I am appearing for the state, my lord. My lord, this is a similar matter like the previous one, my lord. Here also, they have.
I'm praying for a similar order, my lord, and just the notification numbers are different, my lord. Vacancy notification, my lord. Can you come to page 21, my lord?
Vacancy notification is of dated 10th January 2025.
10th January 2025.
Yes, my lord.
Similar direction.
Similar direction,
My
my lord.
lord,
I
sir.
challenge the jurisdiction of Director DDP and S.
Please take down.
And
Similar. এখানে vacancy notification নাম্বারটা আছে page 21. 10th of January 2025. Similar direction, 2nd week of, 3rd week of August 2025.
Grateful, my lord.
Affidavit of substance. একই order.
next one also, my lord, similar.
Call next matter.
My lord, I am for the petitioner, my lord. The vacancy notification, my lord.
Similar issue.
10 January 2025, my lord. Location is just different, my lord. Location is different.
Mr. Sengupta, are you there?
Yes,
Sengupta,
I'm happy.
please take down. আগেরটা সেনগুপ্ত হবে না কিন্তু আগের উকিলটা আলাদা আগেরটা স্টেট অ্যাডভোকেট আগের স্টেট অ্যাডভোকেট নামটা তুমি লিখেছি কিন্তু প্রত্যেকটাতে চেঞ্জ করো এটাও কোন সেনগুপ্ত এফিডেভিট ইন অপোজিশন সিমিলার ডাইরেকশন
My lord. নামটা দিয়ে দিয়েছিস এ? নিয়ে যাবে কাগজটা নিয়ে যাবে। এই অর্ডারটা একটু করবো
similar we have for the state yes what are the issues similar issue 2013 control order
Yes, the one thing, my lord, I find, if the lordship comes to page 5, paragraph 11, if your lordship kindly comes. Page 5, my lord, paragraph 11.
yes
On 20th October 2020, the vacancy notification bearing number so and so for inviting application for license. Vacancy new price of in the area where my client caters business to was published. In pursuit of the same applications, several applications were made. And the
okay
license
license has been issued already
Yes.
license has already been issued so what is your instruction regarding whether he is running the business
My lord, it implies, my lord, that if license has been issued, and next continue lordship kindly read. License number in process of creation of new
okay
FPS
4,000 cards are
were
carted.
carted from the total units. So therefore it is an admission
and the
position.
catering a business too
Yes. So
so
therefore
he has
he
started
is
the
a
business already
necessary party. He has not been made a party. He will be affected. So he should be made a party and he should be served first. And then more the matter can be taken up.
he is not made the private respondent
No.
Not required.
He says it's not required, but according to me, it's required. And then my lordship,
Mr. Hooda, what is your submission?
I have not challenged this notification.
You have not challenged the notification. What you want?
Not the notification that challenge, my lord. What I have said is, my lord, that apart from the notification that I have challenged, earlier also, my lord, there was a notification 2022, my lord. In terms of that notification, my lord, 4,000 cards have already been deleted. Now this is the second notification for further curtailment, which I have challenged. This is just an information, my lord. That
no, it is
only-
correct. I am not disputing that. But the curtailment is started there with the issuance of license in favor of Sahanawaz Mullah.
May I, my lord, once again, my lord, explain?
Yes.
This paragraph 11, my lord, is in respect of a vacancy notice of 2022. In terms of this notification, my lord, one Sahanawaz Mullah, my lord, has already been issued with a license. I have not challenged that. My cards have already been cut. Now this is the second notification.
Which you challenge now? Okay, that is under challenge.
Yes.
Which is a 2030
There is that.
notification, my lord. And my lord, I am told, my lord, that verbally he has been informed that perhaps they will not, my lord, detag any cards, my lord, but that's verbal. So let them file a report, my lord. I have told that. It's a 2013 notification, my lord.
Yes, I can file a report, but kindly do not pass an interim order. This is not a case of that time.
Why not interim, my lord? Lordship has just passed an interim order, my lord, in another matter.
If you not granted any license, then you follow the division bench order.
Yes.
No detagging, no detagging.
Same as item number 11.
11.
Not to issue license till the disposal of MAT 1543. MAT 1543 আছে না? এই যে অর্ডারটা আছে তোমার করা MAT 1543 of 2024 এই ইন্টারিম অর্ডারটা আছে দুইটা
এর মধ্যে দেখা
report in the form of affidavit within 3 weeks. Report in the form of affidavit within 3 weeks by the state, reply if any by the petitioner within 2 weeks thereafter. Considering the facts and circumstances of this case. What is this? Okay. The state authority may proceed with the selection process, but so far as the grant of license is concerned, the same shall not be issued till the disposal of the matter, disposal of the appeal being MAT 1543 of 2024 pending before the Honorable Division Bench. Let the matter go out of the list, parties are liberty to mention. Affidavit of service taken on record.
Lordship.
17, my lord, is under 2024 country. Same order as it.
প্রথমটাই ছিল 15 15 বোধ হয়
Item number 30.
ইন্ট্রি মোডে পেয়েছিস নাকি কোনো
ওই যেটা করেছি এখন আইটেম নাম্বার 13 মিস্টার সুমন সেনগুপ্ত ছিল যেটা ঠিক আছে সিমিলার অর্ডার শুধু এই ভ্যাকেন্সি নোটিফিকেশন ডেটেড 13th of February 13th of December 2024 page 37 affidavit of service similar direction
ভালো এইটা নিয়ে
Item number 18.
15 এটা কি একই
Same as the previous one. 2024.
তো 2024 মানে control order.
detailed report from the state maintainability kept open
Usual order general mandate kept open.
আগেরটার মতো যা করলাম তার মতো যা হবে শুধু ভ্যাকেন্সি নোটিফিকেশন dated 6th of January 2025, page 39. Mr. Shopon Kumar Dotto, learned senior counsel, appears on behalf of the state. A detailed report and maintain will be kept open. And detailed report regarding justification of the Director DDPS to issue such notification, issue such order fixing the minimum number of DRC to be retained by a FPS data. That is the report I want.
Yes, sir.
There are at least 10 of those matters.
I'll try to show. But
Yes,
the
next.
policy matters, Malad, the scope
Yes.
of judicial is very limited.
I have also passed the order on that point.
I'll argue Malad, when the matter comes to point.
That is why the matter of maintain will be kept open.
I'm grateful.
Yes.
Madam, Mr. HON'BLE is appearing for the petitioner. I prayed for no.
Okay, come on tomorrow then.
Petition
Not today.
completely based on apprehension. Not
Okay, madam, come tomorrow.
Yes, great for you.
I want to edit when there is a private respondent that has not yet been
Take the mic.
but there is a private respondent, my lord. But
Yes.
that service is not effected yet.
Okay, you serve the complete the service.
My lord, I have taken instructions since the matter was appearing today. But the license is being issued today. This my learned friend must know, so that
I have
tomorrow it is not said that we have issued a license when the court was in session of the matter. But till now there is no interim order, my lord. My officers instruct that the license is to be issued today.
If it is,
No interim order, then why you are
if
so
it
worried?
is,
Because tomorrow this point will be taken. Then
After
when your
filing of the writ
lordship.
petition, they have issued the license.
yes, my lord.
Yes.
But
So my lord, since my learned friend is taking time today,
I am not taking time. I am saying
I am
that,
informing him.
I am
I'm
passing the order, that would be sufficient.
but what I am saying, my lord, there is a private
Okay,
respondent.
okay, okay.
But what happened? I have taken a specific plea that where the private respondent has constructed his come go down without any sanction.
Maybe that is on the merit. He is not moving it. He will make those submissions when private respondent
in
comes.
the
It can be, it can be.
If
No.
license is not being
Who is
issued
the private
today,
respondent? Have you served upon him?
I have served.
But service is not affected.
No record is found on the website. This is the difficulty.
Okay. Please take down.
I have only
Learned counsel for the petitioner submits that the service upon private respondent is not complete. So he seeks some time. Concerning the submission, the matter be urgent today, list the matter next Monday.
Monday. But what is my learned friend?
Monday.
Monday 21st, 22nd. 22nd of July 2020.
So, Malad, I'll come to court, but Malad, their resolutions are
I
there,
understand.
lists, collapse. Malad, I'll be there. My learned friend need not worry, Malad. I'll come. Meeting is not from 10 o'clock.
Javina?
By
Under the same ID.
22nd court. Grateful.
May I take back the affidavit service?
Yes, yes. Affidavit দিয়ে দিন। Affidavit দিয়ে দিন।
Malad, for the petitioner. Here also, Malad, I have challenged the selection of private respondent as APS dealer. Now, Malad, after taking a lordship's leave, I filed it, Malad. Now, Malad, in the website information shows that the private respondent have not yet received website information is till 12th. Today and day before yesterday's information is not available in the server. I do not know whether he has received or not. Malat, this is my affidavit of service.
I understand. By the next day, that is on tomorrow, that matter can be whether
Tomorrow, yes, Malat. Tomorrow that can be taken up, Malat.
tomorrow you take up the list from the website, whether it was
I
served
can,
or not.
I can.
Not today only.
Malat, I am praying for entry order. Malat, he has only issued the offer letter, not yet license has yet been issued. So, if your lordship, Malat, status quo to be maintained or Malat, any in
Come on
like
tomorrow then. Come on tomorrow.
very well, Malat, tomorrow.
Let me take out a look that the service has been complete. That was
Malat,
I want.
tomorrow, Malat.
Not today.
Time for the petitioner, madam. This is the assigned matter, madam.
My lord, I am for the Union of India, my lord. We are not the answering respondent on the last occasion, my lord.
Private respondents is there, madam.
Private respondent is there.
And then make it, madam, not today.
Not today, not this week. Kalki difficult.
Oh, কালকে ঢুকে গেল কাজ নে ও
Next week
ওই তো একই ইউনিয়ন অফ ইন্ডিয়া who is also union of India. So madam, let it be an
Next week যে কোনো
next Monday, madam, Monday or Tuesday.
private respondent
Monday
আমরা কি বলবো?
Next Tuesday, madam.
As per the direction of the lower court, the
This is assigned matter, madam. Yes.
Next Monday তো একুশে অনেকে আসতে পারবে না তো
তাই
না দিইনি আমি দিয়ে দিচ্ছি
let it be on 22nd, madam. Let it be along in presence of others.
formal order.
Order at page 18. Then, madam, the order at page, madam, 53.
সকালেই বলেছিল যেটা আমি আগে করবো না
Mantri, there is a order of the injunction by the learned trial judge, my lord. Against that, they have prepared appeal. That trial judge order has not vacated, but all on a sudden, the learned additional district judge directed for election of the union. Without that is not the subject matter of the appeal or ye. It could be a ye.
not today না next week করে নিয়ে
Humble submission.
As per the direction of the
আচ্ছা তবে কবে হবে?
next week any day Monday
Next Tuesday, my lord.
direction of the lower court, the election has been
already
conducted and thereafter result has
Report of the relay that
all the
that election is bad.
of
It is relay union, my lord.
challenging of the election order they have come before the law.
So the CO is preferred against the order passed by the learned trial court or
No,
the
no, no, my
first
lord.
appellate.
No. First appellate.
First appellate court.
Yes, madam. I am the petitioner,
You are the petitioner.
my lord.
So first why you are aggrieved against the order of first appellate court?
Well, the losses can see the order at page, my lord, 18 first.
First
Order of
appellate
the
court.
learned trial court.
That is
Page
order of trial court.
19.
That is an order of injunction.
Order of injunction.
Interim injunction, plaintiff and defendant allowed defendant hereby
Has
restrained
paid
from
for the
working as a
plaintiff against the
central
defendant.
office bearer by violating the constitution of defendant number 13.
That is not the subject matter of appeal, that is not the subject matter of the suit.
A member of that union, how he filed this application suit
He
as well as
challenged the election of, by election of
So that's the order of appeal.
my lord, that is under that page 53.
Page
53.
53. 52, 53.
না নাম তো আমরা তো ইউনিয়ন
All on a sudden directed for the year. And my lord, what I am submitting, there is a union, my lord, that is Southeastern Railway Men's Congress.
Just wait, let me read out. I cannot understand your
my lord.
submission.
নাম কি আছে
As per bylaws of the Southeastern Railway Men's Congress, by cooperated within 2 years. So,
This is the
learned first appellate court has allowed to conduct the election.
election, that is not the subject matter of the suit. And losses kindly come to page 19 first.
No, I understand. So what is the now, what happened after that?
After that, the
Election is conducted.
election conducted, but without following the rules and constitution of the Southeastern Railway Men's Congress. That is, they have to give notice for 21 days. Actually, election time takes from the branch.
You can challenge it, no issue. You can challenge it.
No, we have challenged before lordship that order cannot be passed. And Railway Authority gave a affidavit.
In the CO,
I am submitting, my lord. I am submitting.
in the CO, there is a very specific scope.
No, lord.
How can I entertain the CO as a writ petition?
No, no, not that. Sure is not petition. The order of this is wrong. That is my submission. And then my losses can come to next.
Even if order is wrong, it has already been complied with.
Not complied with, not complied with. That is not challenge. Well, nothing. Nothing else. No. That is wrong, my lord. That is wrong. I am submitting for this reason, my lord. That the union has been disallowed to continue as a by the Railway Authority because they did not secure the number of votes in the railway. There's a secured ballot, my lord. And for this reason, my lord, they lost this recognition from the railway. Railway losses can come to their railway affidavit. Losses can supplementary affidavit mine.
Whether result published?
No.
Result
Not that. That union has been de-recognized. That union has been. Let me complete, my lord. May I submit, my lord? May I submit? Then, my lord, losses can be. They have not vacated the order of the target. It is not the.
The direction is that the election may be proceeded, but
As per constitution. As per constitution, 21 days.
Not to publish the final result.
Not to constitution is
order.
Then,
let him complete the argument. I will submit. Let him complete the argument. I will continue. Losses can come to.
No, today all of are ready so that I can dispose of this matter.
Next week, fix the next week. Next week, news Tuesday. Next week.
22nd then.
22nd.
Come, get ready.
Well, I will take 20 minutes from there.
Very well. You
Mr. Bhattaji is appearing as a senior, may appear that day. Because Ranjan Bhattaji.
No hard in part. I will dispose of it one go.
Assignment. It is assignment.
Not one go, not hard in part.
No.
I shall pass an order, no issue. Please take down. The instant CO has been preferred against an order passed by Landed Additional District and Session Judge 12th Court Alipur. 12th Alipur dated 5th of October 2024. 5th of October 2024 in Miss Appeal number 300 of 2023. The Landed Counsel for the petitioner has placed the impugn order. Full stop. Let the matter appear in the list under the same heading on 22nd of July 2025. You start this matter on that day.
I'll take only 15-20 minutes. Yes, Malad. Because there is a constitution, Malad, as per constitution, you have to hold election. And I have prepared the.
No, I just want to know one order of injunction passed by the trial court.
Yes, that is
Thereafter, you prepared.
No.
That thereafter one interim order against the order. They have preferred an appeal before the additional division bench, additional district judge. Additional district judge, being the appellate authority, has passed an order.
Beyond the scope of the appeal also.
Beyond the scope of the appeal.
And the suit. We have challenged the biannual general meeting of 2022.
Okay.
As a member of the.
Okay, I'll take up.
Men's Congress.
Then, sir, you have filed a press read application.
Right. You know what is the writ and what is the civil matter?
There's a pass-through matter.
Pass over matter?
Item number
No, 23 has been called out.
Yes, I called it. There is a passover matter. If both the persons are there, I can take up the passover matter first. Item number 8.
Yes, take passover.
Madam, please.
Yes,
sit.
yes. May I file my report?
But may I file the supplementary affidavit served upon them?
अच्छा देखना ना
State has submitted a report.
Yes, my lord.
But that report, I believe, my lord, certain more documents, my lord, should be there in the report, my lord, because usually, my lord, when the state files report, my lord, they also file, my lord, the inquiry reports with regard to the my lord, the
The
petitioner.
petitioner and the private respondent.
Yes. Plus, my lord, they also, my lord, annex, my lord, the
The entire DLF committee's report, wherein the marks are apparent. Now my learned friend is asking with the detailed breakup. Why 20? Why, how it has come 20?
Lord, may I, my lord,
It's not sufficient, but then I'll take one
Very well.
instruction whether.
Very well, let me proceed.
my lord, may I, my lord, may I continue, my lord? So, my lord, usually, my lord, and second, my lord, the marks given by, my lord, the district level and, my lord, the breakup of, my lord, the marks given, my lord, by the sub-division level is usually annexed, my lord. But if your lordship comes to, my lord, paragraph 20, I'm sorry, page 20, my lord.
Page 20.
Yes, page 2020. Well, I believe, my lord, there is a reason why those documents have not, my lord, come forward. May I, my lord? बोलते रहो. Lordship is at page 20. Now, kindly takes, my lord. Item number 2, my lord. Chand Sultana. Chand Sultana, my lord, is the private respondent who, my lord, has.
Sultana is the private respondent and the petitioner.
I'll come to it. Chand Sultana kindly sees, my lord, the marks given to Chand Sultana 20, 22, 22. So, my lord, the average is 21. Now, the petitioner is number 5. Muhammad Ajimuddin Sheikh, marks given is 15, 14, 15. This is out of 25. So, my average is 14. Now, kindly comes to, my lord, the second part of it, evaluation of applicants, my lord. Now, marks from inquiry out of 75 for Chand Sultana, if your lordship sees, my lord, 54.
Yes.
And total, my lord, 54 plus 21 is 75. Kindly turns over. Kindly sees Muhammad Ajimuddin Sheikh, 58. So out of 75, I get 58 marks. And purposely, my lord, I am given 14 marks so that I am 3 marks less than the private respondent. Now, my lord, like kindly takes up, my lord, the supplementary affidavit once.
So you challenge the marks given by the DLFL.
Marks I have just received. Marks I did not know. Now kindly takes up, my lord, the supplementary affidavit.
District level fair price shop selection committees.
This was just to show the anomaly, my lord. Kindly comes to page 6. This, my lord, is the go down of the petitioner. Page 6, page 7, page 8, page 9. Now, my lord, page 10 is the go down of, my lord, the private respondent. Page 10, 11, 12. But by visual representation only, there is no comparison. The asbestos sheets, my lord, do not have a bitumen coating also. This is the reason, my lord, why I got, my lord, 58 Out of 75, she gets 54. Now, all of a sudden, my lord, out of 25, for no reason, I get 14 and she gets 21, my lord. So kindly, my lord, calls for, so that I can file, my lord, an exception, my lord, a composite exception to, my lord, the report filed by the state and the second report as well. My lord. Kindly calls for a report, my lord.
No, you don't have any objection regarding 58 or 51.
58, my lord, I am the
Yes,
highest. I get the highest marks.
Yes. So you cannot challenge the report of the subdivisional controller. That is the marking of subdivision.
Which I have come to know now. I
Yes.
will not. Why will I?
So you are challenging only the marking of district level fair price of selection.
Correct.
So you can use your reply on that point. Detailed report, what would be? Your number would be 58 always.
It is better if those come, because my contention is that she is not supposed to get 54 also. Kindly sees, my lord, it's an asbestos. It's a leased property. She is not even the owner. I am the owner of the godown.
That's why your number is more.
It should be much more. Not just more, but much more.
Okay.
So if they come up with the, my lord, those two inquiry reports, my lord, and the number breakup, my lord, it would be much easier. I'll file a composite exception to both the reports, my lord, and then lordship would kindly hear it once and for all. Because usually, my lord, lordship is here for in this determination for quite some time. Usually they file all the app, but the reason why they have not filed in this case is quite apparent.
This is the first day they have placed the report.
Yes. Here the doubt, my lord, I can in another matter, but I have got the detail as I have seen. But although, my lord, in this affidavit, my lord, I have disclosed everything. The expert committee report, the marks and all given to all the parties. And initially, I submitted before your lordship that the petitioner is marginally less before the in comparison to the private respondent. Therefore, now he is asking for, I don't know under which provision of law. Still, to clear all the doubt, I can take complete instruction further if required. I'll ask the authority to give me this, the detailed breakup.
Yes,
so, so clear all the doubt. Why he has been given 14 or private respondent given 21 or
Very good. Please take down.
এটা দরকার দেয়নি যখন দেয়নি কেন
আমি চেয়ে নিচ্ছি
And the inquiry reports
Report
also.
in the form of affidavit filed on behalf of the state respondent is taken on record. Full stop. Supplementary affidavit on behalf of the petitioner is also taken on record. Full stop. It appears from the report filed by the state respondent that it missed the inquiry report of the concerned SCFS in respect of proposed shop-come go-down of petitioner as well as the private respondent. Thus, the state is directed to submit a further report containing the details of report of SCFS regarding inspection of proposed shop-come go-down of the private respondent as well as the petitioner.
Inquiry report, my lord.
Inquiry report. Inquiry report. Detailed report. Inquiry report of proposed shop-come go-down of private respondent and the petitioner.
I have already placed the report of the committee. Only the breakup of the marks.
No, I want the report. Inquiry report. As
No, no, it's not there.
And the detail of marks. all the
inquiry report by the SCFS.
It is not there.
That is not there. Usually, in all the cases, you place state authority place this report.
As you lordship.
Okay, you place that.
That should
Let the
come
matter
to-
appear in the list after 2 weeks.
Martin is asking to file another report in the form of affidavit annexing all those.
Yes, submit a further report
My lord,
within 2 weeks. Let the matter appear in the list on 29th of July under the same heading. 2 weeks hole to hobe na 29th. Just wait. Let the matter appear in the list on 4th of August. 4th of August.
Thank you.
Who is for the petitioner?
Your Lordship, most probably there is a change in the petitioner's advocate because when we had gone to serve a copy, the phone was not received. Probably there is a change, but since there was a direction, we are filing it today. Let it be kept on record.
Please take down. State is represented through learned counsel Ms. Sonal Sinha with Mr. Prasad, Mr. Abhishek Prasad. Full stop. Report in the form of affidavit filed on behalf of the respondent number 1 to 7 be taken on record. Full stop. None appears on behalf of the petitioner. Let the matter appear in the next week under the same heading.
Grateful, Your Lordship.
Huh.
24, I am for the petitioner. But affidavit has been exchanged, you fix a date for hearing. Any day.
Today is fixed for hearing. Today itself is fixed for hearing.
The hearing matter, affidavit has been exchanged, affidavit in opposition filed, I filed also reply. Any day.
Yes, it is ready for hearing. Huh? Because the interim order is there, so therefore there is no urgency.
No, there is urgency.
There is urgency on my part. Mr. Saras, but there is no urgency. Because he is merrymaking with the interim order.
In his chamber in the initial stage. Whether here my learned senator has done it or not, just ask one question. When he is petitioner.
So, come on 22nd next week.
Can it be taken up at 2 o'clock, my lord?
Today.
No, on this next date that.
Then I have to take up the diary. Okay.
Shubidha হবে.
When the matter is ready.
Ready.
22nd.
হবে.
Okay, 2 p.m. 22nd, 2 p.m.
Interim order is till 21st.
Not 21st.
Interim order is till 21st.
Yes, EPOS was limited because lawsuit wanted to hear out the matter.
It extended for some time so that.
Okay. Pleadings.
Oh, sorry, my lord, I'm extremely sorry, my lord. It may be on 23rd, my lord. 22nd, I have
That's
something.
good. Then I have to look at 23rd. Then it will be second matter.
Second matter হবে না? Yes. But 22nd and 24th accepting. These are some.
Okay, 23rd, come on 23rd. Let me fix on 2 p.m.
Other matter.
There is another matter.
Other matter is there. So after that, I will take up this matter.
হয়ে যাবে তো ভাই তোরই ম্যাটার তাহলে ওইটা পরে করিস let it be taken up on 23rd, but let us try
23rd at 2 p.m.
My lord.
Yes.
Very good.
And interim order be
have completed. Full stop. The matter is otherwise ready for hearing. Let the matter be fixed for hearing peremptorily on 23rd of July 2025. Especially marked at 2 p.m. Marked at 2 p.m. Full stop. Let the interim order passed by this court on the earlier occasion is further extended till 29th of July 2025 or until further order, whichever is earlier.
I appear for the state respondent.
Sixth Lordship, I am for the petitioner, Lordship. Lordship,
I appear for the state respondents.
Oh, but I am for the petitioner. My lord. My lord, I'm sorry. My lord. I've been briefed in this matter. My lord, in this matter, a vacancy has been notified. Kindly turn to my lord, page 33. Pursuant to a vacancy notice dated 10th April 2023, I have participated in the selection process, which will appear from page 33.
Yes.
That's my acknowledgement. Kindly see the date, 24th of August 2024. Inquiry has been conducted. I got the first position. Then district level selection committee also selected me first position. Then one of the candidate lodged a complaint against me that a criminal case is pending against me. Your Lordship, kindly turn to page 39. This is the crux of the case. I don't know whether it is a good ground for rejection of my candidature. And I have categorically denied the same. This is not related to essential commodities. No police case is pending.
No, the page 39 is the no,
No.
letter.
Letter of the police authority. SI Uttam Kumar Sarkar, Lalgola PS, Murshidabad PD, on 21st of February 2025, written to the subdivisional controller on his query, kindly come to reference your good office memo number so and so, submission of report, CV, Mohammad Mustafi Rahman, son of so and so. Reference to the above noted, I am submitting the report of CV so and so. As per order, he was engaged a Lalgola PS as civil volunteer since civic volunteer in the year 2013. So far received information, it kindly take note. So far received information, it has come to know that he is demolished. I fail to understand. 14th October 2024, from service due to his anti-government activity. His local reputation is very poor. This is the police authorities. Inquiring officer submitted report saying my reputation is very good. I got the first position. District level sub-selection committee given me the highest marks. I got the first position. Then a complaint has been lodged by one of the unsuccessful candidate. On the basis of that, subdivisional controller sought for a report from the local police station, and the OC written this letter. Then kindly see my objection to that. There is nothing correct. I have categorically stated page 40. I sought for inquiry against the concerned police officer at page 40 and 41. Kindly turn to page 41. Second paragraph, that it mentioned here that I asked for strict proof of supporting legal documents justifying the claims made in this report. In the absence of such proof, the officer responsible must be held accountable, and also immediate departmental inquiry and discipline action against me must be given, that a legal proceedings to be initiated against the issuing officer under relevant sections of law, including provision of the IPC so and so. I urge you to take specific action against the officer. Then I have served them through SP also. But today my question is that, my lord, even I am not admitting any of the complaint, even if there is, unless there is a case pending against me under the Essential Commodities Act, it does not say even there is a complaint lodged against me or any FIR proceeding has been initiated. It says demolished from service.
It should be dismissed, I think.
Whatever maybe, I cannot assume whatever he has been written, I have to
This
read
is
it.
not regular service, it cannot be termed as a dismissed.
Absolutely, my lord.
Now,
Civic
well,
volunteer,
Service in the civic
retrenchment may be used.
This is the civic
detained,
volunteer.
it should be detained.
Yes.
Detained, not
Detained.
demolished.
This is the, I can improve upon it.
But whether this letter stands on the way to get my license, that's my only question. Even if there is a police officer says my reputation is bad without any document, and kindly see the language. So far received information, it has come to know. Why the subdivisional controller wrote a letter where the inspecting personnel, after conducting inquiry, submitted a report saying that my reputation is very good in the area. And the district level sub-selection committee also found me most suitable candidate. Only on that ground, my license has not been handed over to me.
So what is the status now?
No one has been at least given till today. Jani provision. May I place the provisions of the law? What is the bar to get the license? Only your lordship knows so far the essential counsel act is concerned. So that it cannot stand on the way.
Yes, Mr.
My lord, the
Dorothy.
lordship kindly sees the prayer at page 25. What is the prayer they has made?
This matter has been assigned to your lordship.
Read it.
This matter has been assigned. That point has been raised by my learned senior friend. I am proceeding on the basis of the prayer B. All other prayers I am withdrawing. I'm page 25, prayer B.
Yes, I'm placing that. Mandamus commanding respondent so and so to grant APS license in favor of the petitioner against the said vacancy of fair price of such and such near such within Lalgola block, Lalbagh subdivision, video vacancy IT so
This
and
might
so
be a
subdivision
Mandamus.
the district of Murshidabad. Now, my lord, this is prayer 1. The next mandamus is lordship kindly, no, it continues. Prayer C. Mandamus commanding respondents, the means cancel communication letter of the concerned police station dated 21st of February 2025 in connection with memo number so and so and do not give any effect to the same. Now, my lord, here, my lord, lordship kindly says that my learned friend has placed page 39. It is not in dispute that he was called for interview. But at this stage, this is that page 39 is addressed to the subdivisional controller concerned by the SI. Your good office memo number 141. I don't know because I don't have that memo number at this moment with me. I'll bring on record. The submission report regarding CV volunteer 105 Mohammad Fizur Rahman, so and so. With reference to the above noted, I am submitting the report of CV volunteer 105 Mustafizur Rahman. As per order, he was engaged at Lalgola PS as civic volunteer since the year 2013. So far as received information, it has come to know that my language is not correct, but then he is demolished on 14th of October 2014 from service due to his anti-government activity. Lordship kindly knows this. It is, I think it should be, it's not demolished. But the SI of police possibly knows English like me. That's why he has he's chosen the word demolished. It should have been dismissed or demolished. I don't know what is how that. But then the important part is due to his anti-government activity. He was a civic volunteer, discharges quasi police services. Now here his reputation is very poor. Most important part is due to anti-government activity. For that reason, he lost his job, either by a dismissal or retrenchment or whatever. But then the important part is anti-government activity that the police says. And now, my lord, whether this person should be granted a license or not. Because that is his prayer. But in my humble submission, that the person against whom the anti-government activity has been proven by reason of dispensation of his services as civic volunteer, he cannot be considered to be given a license of a fair price shop. This cannot be done. So, my lord, today, my lord, if your lordship, my lord, there is no scope for an interim order. If your lordship wants, I can come with a report. But, my lord, the objection that has been made at page 46, page 40, lordship kindly sees the penultimate paragraph of the representation that he made. I urge you, the penultimate paragraph I am reading, page 41. It is his representation. I urge you to take this matter with the utmost seriousness and immediately rectify the wrong done to me. No wrong has been done to it. It is the finding of the police that he was involved in anti-government activity. That's why he lost his job. So the reputation and credibility of a law-abiding citizen cannot be destroyed by an irresponsible act of a police officer. Failure to act swiftly will compel me to escalate this matter at the highest level and administrative level. It is open to him. He is a citizen of India. But he doesn't deserve to be a price of licensee. Similar, in spite of he being interviewed for the purpose, well, it cannot be granted to him because the police says that he lost his service due to anti-government activity. He claims government license to run a free fair price shop. So this, my lord, first of all, my lord, whether your lordship will consider this or your lordship wants, I can come with a short affidavit.
My reply is
But
that
my lord,
whether we shall proceed on the basis of the statement of the bar or the statute. There is a specific provision. These are the profession who is not entitled to get the license. So let you kindly take up page 1.19 of the book.
Oh yes, sir.
Which they were. No FIR, no complaint. According to my learned senior friend, my service has gone.
I have not placed on record. It's only the submission. I am relying on a
It
document.
does not
No,
appear.
I want to know why the SI has sent the letter.
The
At
part
the- at the-
that
at
why
the
the
invitation,
subdivision
subdivisional
transfer inquiry.
contact.
Why subdivisional contact
Yes.
for a report?
In all cases, they are doing so. My learned senior is appearing so many matters. Why subdivisional prompted to sought for a report from the police under which provision of law? Controller never suggest
That
to
I'll
take
have
any
to
report from
ascertain.
the
I'll have to
officer.
bring the
Yes.
office memo of the subdivisional controller.
There is a reference.
Yes, there is a reference to the government. I don't know under which circumstances this letter was
Yes, that's what
given
I
to the
want
police.
File a
What is
report
the
in the meantime, status quo, not to grant any license to anybody.
Why status?
I am the best candidate.
Why status quo?
Under which provision of law subdivision are sought for this report? Overwhelming.
That I'll
Give
explain by
advantage
filing
to
an
somebody
affidavit.
else.
By filing an affidavit.
I have never seen. I have very few cases that a subdivisional controller seeking a report from the police to withhold the license of a particular.
Very well. The superintendent is also a party in this matter.
Yes.
Let
Which is
me
party.
call for a report from the superintendent. also.
Yes. Disciplinary proceeding should be initiated that gentleman. Subdivisional controller as also the police officer.
Subdivisional
Why
controller,
so overwhelmed?
home and he will affairs.
Tell the officer in charge, SP, both are party.
Yes,
Which form?
superintendent of party is police is party. Respondent
Yes.
10.
Let me call a report from the
Both from the subdivisional controller as also from the police. Which
All
prompted the
Malad
subdivisional
comprehensive
controller to
report on
seek a
behalf of
report
state authorities.
from an officer in charge.
All Malad comprehensive report on behalf of all the state government authorities. Particularly from the police or
Absolutely.
yes, you
Yes,
can submit a comprehensive report. of it.
yes, on
both
behalf
of
of the
them. They will have to
respondent.
kindly indicate that the police and also the food department.
Very good. Please take down. Petitioner applied for APS license in terms of vacancy notification issued by, in terms of vacancy notification issued by Subdivisional Controller Lalbagh, District Murshidabad. Petitioner application was received online. Full stop. His proposed shop come go down was inspected by the concerned authority. Full stop. Petitioner was called for on an interview by district level fair price shop selection committee.
পুলিশ রিপোর্টটা কোথায়? পুলিশ রিপোর্ট ফাইল করা হয়েছে।
Full stop.
কোথায় কপি? Where is the copy?
It is the contention of the petitioner that
What?
the subdivisional controller concerned
দেখি
had sent a memo.
This report kept on record, released for want of
No, cut. It is the contention of the petitioner that the candidature of the petitioner, no, though the petitioner is the most suitable candidate to have the license,
So then you can come. এখানে তো আমরা ফাইল করেছিলাম, তো আমাদেরটা গেল।
but he was denied to the license in terms of a memo of SI of Police, Lalgola PS, dated 21st of February 2025, containing some frivolous allegations. It is the contention of the petitioner that the license of the petitioner cannot be denied if he was not entangled in a case under Essential Commodities Act. The further submission, there is no pending cases against the petitioner. Thus, the act and action of the concerned authority is illegal in the eye of law. He also challenged the justification of the memo issued by the SI of Police, Lalgola PS, dated 21st of February 2025. Mr. Swapon Datta, learned counsel, appearing on behalf of the state, submits that one person whose local reputation is very poor, and who has been
lost his job,
who has been
That's not correct. That's not correct. Does not say you.
demobilized from his service as a civic volunteer due to his anti-government activity, cannot be allowed to run a government license. Full stop. Considering the entire issue, it appears that it appears to this court that the reason for issuing memo by the subdivisional controller to the police regarding the reputation of the petitioner is unknown. However, the subdivisional controller, Food and Supply, has no authority under the control order 2013 to issue a memo upon concerned police station to justify local reputation of a candidate. Considering the same, I intend to call for a report from both the sub-divisional controller as well as the superintendent of police, Murshidabad, to justify the action of the concerned authorities. Full stop. The report of sub-divisional controller shall contain the justification why he issued a memo to the concerned police authority seeking local reputation of the petitioner. Full stop. The report of the superintendent of police shall contain the detailed finding, the justification of detailed finding, and the memo dated 21st of February 2025, issued by the SI of Police, Lalgola PS. Full stop. Next part. Let a comprehensive report be placed by the respondent authorities within 3 weeks from date. Reply exception against the report be placed on record by the petitioner within 2 weeks thereafter. Release the matter on 3rd week of August 2025 under the same heading. Full stop. Next paragraph. Considering the facts and circumstances of this case and considering the issue that the petitioner's candidature has not cancelled yet, I think it necessary to pass an order of status quo. Accordingly, there should be an order of status quo in respect of the impugned vacancy till a period of 8 weeks from date.
Lordship given us the 3 weeks, 4 weeks, 3
weeks.
3 weeks time.
A comprehensive report. Both reports shall contain one report from the STFS and one report from the police authority.
Status quo.
A status quo. Till 8 weeks from date.
But the consideration of my license question is not mature as on date.
Status quo as on today.
That's why the candidature has not been cancelled yet. You have not passed any order regarding cancellation of the candidature.
No, that the stage has not come.
Okay.
Get through it.
কি দেখো
That I appear for the petition.
That don't I do.
I am appearing for the UGC.
My lord,
Yes.
my learned senior friend Millard, on the last occasion Millard, passionately relied on Millard two judgments indicating Millard, the fact Millard, for the purpose of recapitulation, certain benefits were conferred upon Millard till 2016 Millard in respect of the college university teachers of the West Bengal. Now Millard, suddenly Millard, these benefits were withdrawn for a period of 3 years, and on and from 2020 Millard, the policies adopted by the UGCs, Millard, it was followed, and Millard, they have started giving Millard the same pay scale Millard as that was used to be conferred upon us Millard till 2016. My contention consistently Millard before your lordship was that why this gap period? In response to such Millard, the learned senior advocate representing the state Millard referred to judgments which Millard, nothing but a reiteration of the constitutional principle Millard upheld by the Supreme Court, that in a policy matter, it is a choice of the government what to do and not to do. Now, Millard, the court normally Millard restrained itself by adopting Millard self-imposed restriction, Millard by not to interfere with such policy decision. But the court has consciously used Millard that when there is an element of arbitrariness, malafide Millard, though the court can. So the policy of the government, even if it is a choice or discretion, such discretion must be informed by reason, and that same must be reflected from the policy decision.
Yes.
Now, Millard, it is not unknown to the Millard, the executive as well as Millard, the other branches of the constitution, that Millard, every policy Millard is basically for promoting a public good. Now, Millard, the government has chosen to continue with this public good for a specific target group, that is the professors of the college university, Millard, that is we are, Millard, the teachers, Millard, that was conferred. Millard, this conferment of the benefits were just this conferment of benefit, Millard, that is a choice, conscious choice of the government, Millard, following Millard the UGC policy. Why I tell your lordship, I will show. Suddenly, Millard, there was a gap. It was withdrawn. From 2019, government has, Millard, Mr. Bandyopadhyay Millard, my learned senior friend, has consciously used a brilliant word. They said we followed but did not adopt. But the question is that ultimately, the benefit that was conferred upon us in till 2016, that was implemented and followed. The followed and implementation, whether it can be divorced from the word Millard adaptation. If you follow something and acted upon, then whether it is something and you cannot say that it is not adaptation. Mr. Bandyopadhyay, my learned senior friend's specific submission that it was followed but not adopted. My respectful submission. Sorry, Mr. Ganguly, Millard. I'm sorry, I stand corrected. My learned senior friend said that the state has followed but not adopted. Millard, I said, Millard, in Bengali there is a popular term, Millard, Sonar Pathor Bati. It takes us nowhere. Millard, law, Millard, discards, Millard, the principles of uncertainty. It takes us nowhere, Millard, if the state says that a financial benefit, which is a conscious decision of the government, without there being adaptation, Millard, only following Millard, it means nothing. Now, Millard, why I tell your lordship? The page 37 of the lordship's brief. Only Millard, clause Roman 4.
Yes.
Other recommendations of pay review committee of UGC. So it's a policy of the UGC. And why I said clause 4, Roman 4, my lord got it.
Yes.
The scheme may be extended, may I read for my lord? The scheme may be extended to universities, colleges, and other higher educational institutions coming under the purview of state legislature, provided state government wish to adopt and implement the scheme subject to the following terms and conditions. Wish to adopt and implement. Millard, this was way back in 2017, Millard, page 32. My lord, kindly take explain, Millard. So, on the date, this was implemented and adopted. Governments wish to adopt. Initially, there was a discussion for the government. Government has adopted, wish to adopt and implemented. The government has added, Mr. Ganguly, my learned senior friend said, state has followed. But the term adaptation, Millard, was eradicated. I said this cannot be. Am I clear to my lord?
Yes, I understand.
Yes. Now, my lord, the paragraph 13 of the affidavit, opposition, Shiladitya Chakraborty, my lord, page 13. Oh. এটা judgment of Millard, I apologize, Millard. Paragraph, page 13, Roman 21, Millard. My lord, got it?
Yes.
Yes. However, being a model employer and with a view to enhance of salary structure of teachers and other academic staff of colleges and universities, in consideration of the better delivery of the educational instructions upon the students, and state government has revised the scale of pay of teachers, other academic staff of the state-aided universities and government-aided colleges of the state comparable, similar to that of the recommendations made by the central government. Page 37, 27 policy framed by the UGC, clause 4 is clearly, Millard, in line with, Millard, paragraph 21, page 13. State aided, similar to that of the recommendation made by the government as stated, above out of its own volition and independent of the central government scheme. Kindly see the element of contradiction. One hand, you said 17 you followed till 2019, adopting and implementing. You said that it revised the scale academic start in line similar to that of. Similar to that of, there is a reference point. Past practice is to follow. Till 2016 you followed. 17 the policy. Now 16 to 19 you did not follow. So policy, Millard, taken by the government in a welfare state, Millard, subject to correction, Millard, and I hope that Mr. Ganguly, by reason of his inherent generosity and fairness, Millard, would concede to this proposition of law that whenever state, Millard, propounds a policy, it is essentially at the end of the day to be constituted as for a public welfare. Now, Millard, public policy, whether it is distributive, redistributive, constituent, and substantive, whatever may be the nomenclature of that policy, Millard, the four kind of policies, Millard, known to the law, Millard, this substantive policy or constituent policy, targeting a special group, conferring the benefit in order to enhance the salary, augmentation of the status of a particular educated class who imparting education, Millard, engaged in higher education service. Millard, this was an object of the government to promote this status in line with the policy adopted by this. So, Millard, sudden stoppage of these 3 years and not to give arrear, there was not a morsel of proof or semblance of evidence, Millard, indicating the minds of the government, even a file note, that, Millard, the government has chosen to take a meander, Millard, not to give for these particular 3 periods. And there was a specific intention and formation of mind based on subjective satisfaction of the government, based on, Millard, the economic policy. Nothing is there. Now, Millard, what is the consequence of such silence? Millard, such silence is, Millard, a clear indication of a climate of unpredictability. You adopted certain things, past practice, for a continuous period, and with regard to a class of employees, the benefit was conferred upon. Again, in 2019, you decided to comply with, in line with the policy, and suddenly this stoppage and silence. What is this? That means this middle period, when you maintain angelic silence, it did not indicate your mind. The government policy cannot, my lord, make such climate of unpredictability. This unpredictability, my lord, has been discarded by the Supreme Court. I take my lord's kind attention, although in reply, my lord, it would be unfair on my part if I deny, my lord, their right to, my lord, distinguish this judgment, my lord. I only, because I was, my lord, I could not anticipate the state would come up with this, my lord, proposition of law, which is possibly not countenanced by the Supreme Court, my lord. 2024, 3 SCC, page 799, paragraph 40 and 44. 41. 2024, 3 SCC, 799, 40, 41, 44. 799, 799. My lord, I seek my lord's kind indulgence. 40, 41. এটা বার করে দিবি একটু, এটা বার করে দিতে পারবি একটু, এটা দিন তো জজ সাহেবকে। 40, 41 and 44. এটা বার করে দিবি। I am taking only 2 minutes time, my lord. Kindly pardon me. $799, sir. 799. 40, 41, 44. ছিল এটা জুড়ে গেল ওনার সাথে। Millet, fairness in state action.
40, 41
and 44.
44.
Millet, I'm only 1 minute time, Millet. I'm finding it. শোনার তথ্য প্রয়োগ করুন। আসছে না, এই ঘরে আসছে না। হ্যাঁ, না তাই না। Millet, আসছে। Oh, sorry, Millet, I apologize. Actually, network issue, Millet. 40, 41, 44. At the cost of tiring repetition, Millet, I submit that, Millet, this yes, I'm sorry, Millet. I'm grateful for your lordship's patience and generosity, Millet. 40, Millet, the principle of fairness in action requires that public authorities be held accountable for their representation, since the state has a profound impact on the lives of the citizens. Good administration requires public authorities to act in a predictable manner and honor the promises made or practices established, unless there is a good reason not to do so. In such and such held that public authority should objectively justify that there is an overwhelming public interest in denying a legitimate expectation, we are of the opinion that for a public authority to frustrate a claim of legitimate expectation, it must objectively demonstrate by placing relevant material before the court that its decision was in the public interest. The standard is consistent with the principles of good administration, which require the state actions must be held to scrupulous standards to prevent misuse of public power and ensure fairness to citizens. Now, Millet, next, another significant development in the jurisprudence pertaining to the doctrine of legitimate expectation is the emphasis on predictability and consistency in decision-making as a facet of non-arbitrariness. Ram Pravesh Singh, it was held, the doctrine of legitimate expectation applies to a regular, consistent, predictable, and certain conduct. Similarly, in such and such case, the court observed that an executive decision without any basis in a principle of a rule is unpredictable. It was held that such a decision-making process contradicts the principles of legitimate expectation and is antithetical to the rule of law. 44 says, in a constitutional system rooted in the rule of law, the discretion available with public authorities is confined with clearly defined limits. The primary principle underpinning the concept of rule of law is consistency and predictability in decision making. A decision of a public authority taken without any basis in principle of rule is unpredictable and is therefore arbitrary and antithetical to the rule of law. The rule of law promotes fairness by stabilizing an expectations of citizens from public authorities. This was also considered in a recent decision of in the court such and such, wherein it was observed that regularity and predictability are hallmarks of good regulations and governance. This court held that certainty and consistency are important facets of fairness in action and non-arbitrariness. Any good regulatory system must promote and adhere to the principle of certainty and consistency, providing assurance to the individual as to the consequence of transactions forming part of his daily affairs. This does not mean regulators' authorities cannot deviate from the past practice, albeit any such deviation or change must be predicated on greater public interest or harm. This is the mandate. So, my lord, it can be presumed, not assumed, that it can be presumed, my lord, with the element of certainty, that till 2016 you followed a practice, in addition to a legitimate expectation, your consistency, and 2019 you started, 6 years have passed, almost. You maintain this consistency. So, it is a definite element of proof, my lord, the government has acted in a public for a public interest. So that sudden departure, the government did not show that it was not for the public interest. Am I clear to my lord?
Yes.
So, my lord, page 37, clause 4, read with affidavit in opposition, 13, clause 21, clearly indicates that ultimate reference point did UGC policy. So, you followed, you adopted, you implemented, but your silence is not explained. So, that is not, my lord, fairness in action, because it deviates from the path of consistency, and, my lord, the huge beneficial, my lord, the financial, my lord, it's an onslaught on my financial structure. My individual rights as an employee, my lord, government is a role model employer. The state has admitted in its affidavit. But the government did not indicate its mind. It has to be predicated, my lord. So the predictability, consistency, all are facets of, my lord, Article 14. So government, my lord, here has not placed any material that this was dropped, curtailed with the element for a particular reasons. And, my lord, these reasons are absent. And even if in affidavit it cannot be done. And the next question, Mr. Ganguly, my learned senior friend, has tried to persuade your lordship by saying that whether any discretion was conferred upon them. Once you have followed this in 2017, page 38, state government, clause G and H, taking into consideration other local conditions, may also decide in their discretion to introduce pay higher than those mentioned in the scheme, shall give effect to the revised bands, scales of pay from 1/1/2016. However, in such cases, the details of modifications proposed shall be furnished to the central government. My lord, date is very important. From that date, my lord, I was not given. We were, my lord. And central assistance shall be restricted to the pay as approved by the central government and not to any higher pay fixed by the state governments. Payment of central assistance for implementing this scheme is also subject to the condition that the inter scheme of revision of pay scales, together with all conditions to be laid down by the UGC by way of regulations and other guidelines, shall be implemented by state governments and university colleges coming under their jurisdiction as a composite scheme without any modification, except in regard to the date of implementation and pay scale mentioned in herein above. There was no scope for the government without approval from the UGC and the central government. The modification, the scope for modification, as Millard propounded or advanced Millard, there was no scope. There was no scope for the government because all the time government mentioned the central government policy that is reflected to this 2017. That scheme is there. Now, my lord, 2008. ওই judgment টা কি? 1343. My lord, may I read? Then I will, my lord. এক সেকেন্ড পাতাটা হারিয়ে গেল। Millard, I will hand up, Millard, the judgment 2008 volume 2 SCC 672. This is, Millard, paragraph 42. 42, Millard. While acting as a state within the meaning of Article 12, it is imperative, Millard, this was a Delhi development, while implementing statutory power, upholds the fundamental rights and strives and to give effect directive principle of state policy, we cannot also shut to our eyes to the fact that in terms of Article 37 of the Constitution of India, whereas the provision of Part 3 are justiciable, the provision of 4 are not, only when an action of the state is taken to give effect to any provision of Part 4 of the Constitution of India, which is not otherwise ultra-vires the Constitution, of offends the principle, the same may be upheld, having regard to the provision of Art 3 thereof. The action of the state, therefore, must be first instant adjudged on the touchstone of fundamental instant and the provisions contained in the Parliamentary Act and regulation framed as also in the terms of the contract into by the parties. We may, but Millard, in this case, the reason for reading this paragraph 2008, we may or may not agree with the submission of the learned counsel to appellants that the right of housing arising out of such a scheme is a fundamental right with the meaning of Article 19 and 21 of the Constitution, but there cannot be any doubt whatsoever that the action state must satisfy the principal requirement, Article 14, treating persons similarly situated equally and grant of equal protection them, reasonableness and fairness, the same principle. So when you say that you are following that in order to augment, Millard, my pay structure, that means you are taking a reference point of those, Millard, who are already covered by the UGC. Am I clear? So, Millard, the only, Millard, in law, my respect to submission is that in law, everything is with reference to context. Here, Millard, context is, Millard, the UGC. Here, the reference point is the elasticity of their jurisdiction, how far it can, Millard, be extended. The elasticity is limited, discretion is limited in the touchstone of the policy. Once you adopt it, you have to follow it. You said you adopt and followed. Then you said, in the affidavit, you said you adopted and implemented. In the submission made at the bar by my learned esteemed senior friend, that they followed but not adopted. We will go by the records. So today, you did not justify, you mean state, as to why it could not be followed. And ultimately, Millard, I was visited with, Millard, a severe financial disparities. You treated the equal unequally. And not only that, Millard, this judgment 24(3) SCC, page 799, paragraph 40, 41, 44, Millard, it is a reiteration of Rai Pass case, Millard, 74 Supreme Court, Millard, 5 pages judgment, Millard. And Millard, Justice Iyer was also a party to that. Millard, this is also said, Millard, the path of predictability. Court must know, people must know that, Millard, the government, Millard, has adopted a consistent practice. I can predict the action. Predictability, my lord, has become a part of Article 14. Why? Because certainty of law, my lord, is a rule of law. My lord, 2008, Volume 2 SCC and 2014, when I said, my lord, it speaks about, my lord, governance. My lord, with deepest respect, my lord, I cannot show your lordship, my lord. I submit from my memory. In 1950, the Pandit Sarvapalli Radhakrishnan defined constitution, my lord, constitutionality, my lord. It is synonymous with the term governance. Constitutionality means governance, my lord. Your lordship will find this reference in the Constitution's 10th or 12th volume book, Somaraditya Pal, written by Mr. late Somaraditya Pal, eminent barrister, my lord, of this institution. My lord, there, my lord, it has been quoted. Constitutionality means governance. The court, Supreme Court, my lord, taking the last stone of the Pandit Sarvapalli Radhakrishnan, it defines, my lord, it is a constitutionality, constitutionalism, my lord, that it is a governance. I am governed by you. You uphold the rule of law. Rule of law is embedded in Article 14. Article 14 is a constitutional promise given by the constitution draftsman, and parliament is accountable to the people. All parliamentarian is accountable to the parliament. So you have given me the right. Today you cannot say from the bar, which is contrary to your affidavit, contrary to the policy, that such denial was justified because the court cannot enter into the policy. The Supreme Court, my lord, although adopted many a times the principle of self-restriction, not to cross the Lakshman Rekha, but in case of violation of Article 14, the Supreme Court has shown, my lord, zero tolerance. And 2008, 2 SCC, my lord, paragraph 42. The page. Millard, yes. Millard, page 46 of your lordship's brief. Millard, I brief petition, page 46.
Yes.
I am directed to refer to the proposal for grant. It is dated 21st July. Proposal issued by the Government of West Bengal Ministry Department of Higher Education. Proposal for grant of interim relief to the serving college and university teachers, pensioners covered under UGC ITC pay scale. I am directed to refer to the subject mentioned above and to say that this department moved to Finance Department with a proposal for extending benefit of grant of interim relief to the serving and retiring teachers of the government college, government aided college, and state aided university in the state, in the same manner as that have been allowed for whole-time regular serving state government employees and such employees of government-sponsored aided educational institutions, local bodies, statutory bodies, board, corporation, undertaking, etc., and their pensioners in terms of Finance Department's memo number such and such. The Finance Department has opined that since the college and university teachers as well as pensioners covered under UGC ITC pay scale are not included in the terms of reference by 6th Pay Commission. So I am already covered. Why I say, Millard, that predictability is the essence of Article 14. So in 21st July, the government memo is issued that you are covered by this. So question of following and not adapting, not implementing, these are all, Millard, naive. The reasons are nebulous. Court cannot look into this, subject to correction. The moment I say, my lord, it is a policy decision, don't interfere, that means, my lord, I am closing the doors of Article 14. The government was conscious that I am already covered. 1/1/2016 to 2019. Why did you stop? I put this question to myself. So when I was covered, there is no question of stopping. And you curtailed my benefits. And you did not give us any opportunity. And you did not place any morsel of proof that why this was done. Court cannot read the mind of the state. State cannot, my lord, develop its case through affidavit. So today, and now, my lord, since the government is the representative of the people, my lord, there is a celebrated case, my lord, 86 Supreme Court, Brajanath Ganguly versus Union of India, Inland or Water Corporation. A celebrated case still holds the field. And, my lord, apart from the public interest litigation and these judgments, my lord, delivered, my lord, it made the Supreme Court of India and transform it to Supreme Court for India. 92 only. AIR 86 volume 3 SCC, page, my lord, 156. I will read and, my lord, hand up. My lord, your lordship. Only the last line. The Indian Contract Act does not define expression public policy or opposed to public policy. From the very nature of things, the expression public policy, opposed to public policy or contrary to public policy are incapable of precise definition. Public policy, however, is not the policy of a particular government. It connotes some matter which concerns the public good and the public interest. The concept of what is for the public good or in public interest, or what would be injurious or harmful to the public good or public interest, has varied from time to time. As new concepts take place of old, transactions which were once considered against public policy are now being upheld by the courts, and similarly, where there has been a well-recognized head of public policy, the courts have not shirked from extending it new transaction and changed circumstances, have at times not even flinched from inventing a new head of public policy. There are two schools of thought, the narrow view school, the broad view schools. According to the former, courts cannot create a new heads of public policy, whereas the latter countenances judicial lawmaking in this area. The adherents of the public policy narrow school the adherents of the narrow view school would not invalidate a contract on the ground of public policy unless that particular ground had been well established by authorities. Hardly ever has the voice of Timorous spoken more clearly and loudly in the case of law. Now, my lord, I am skipping the last paragraph. It is thus clear that the principles governing public policy are capable on proper occasion of expansion or modification. Practices which were considered perfectly normal at one point of time have today become obnoxious and oppressive to public conscience. If there is no head of public policy which covers a case, then court must, in consonance with the public conscience and in keeping with the public good and public interest, declare such practice to be opposed to public policy. Above all, in deciding any case which may not be covered by the authority, our courts have before them the beacon light of the preamble to the Constitution. Lacking precedent, the court can always be guided by that light and the principle underlying the fundamental rights and the directive principle enshrined.
Paragraph
92. So, my lord, I conclude here, and writ petition may kindly be allowed because the state has taken, my lord.
There can be a reply to a reply, definitely. But whether this was a reply or a fresh submission,
I only counted.
Limited knowledge and understanding.
No, I have no knowledge.
No. I always learn from.
No, my lord.
We have a scope and opportunity, but judgments and all are new.
Okay. Argument close.
Oh, sorry, my lord. The Tamil Nadu is not applicable because this was whether challenge or upheld, I do not know. One hand you say UGC followed, and others said that, no, Tamil Nadu has. This.
Distinction has not been made. New.
No, you have said.
No, that is why this was supposed to be in the reply, but.
No, I'm said, sorry, because I was, Millard, feeling embarrassed, Millard, since that this gentleman was standing behind your lordship.
Okay.
No, Millard, that lunchtime is here. I only, Millard, this point I missed during the period of reply. This higher education revision of pay scale allowances, teacher and university government-aid colleges, it is a state of Tamil Nadu. In West Bengal, consistent and until 21st July also, that they are following UGC, which in paragraph 37. This reference is unknown to us, whether it has been challenged, why it is contextual references here applicable, and when such reference our court has appealed or not, and when such Tamil Nadu, because in the affidavit in opposition, I do not find any semblance of this.
There are others too. We have pointed out only in one with respect to a particular state that this happens
and in the case of petitioner, Millard, your lordship never allows the petitioner give indulgence to adopt a negative equality. So the state is also a litigant. State cannot adopt a negative equality and cannot change a stand in a capricious manner. And this is a knee-jerk reaction, Millard. Suddenly, Millard, the state has come with this. It was not, Millard. It did not find in place, Millard, in the affidavit.
Ultimately, what has been prayed in the writ petition is my curtailment of my right. What has been given in the
not UGC right. You followed it. You said I followed, but
UGC gave a particular right to us.
It was a duty.
Okay. Hard. Please take down argument on behalf of the parties conflicted. Merci.
But I am extremely grateful.
Give me the copies of these books.
My junior, yes.
Not the entire books.
No. Only first page and the paragraph.
Yes.
Statement what is challenging argument তোমার একটা যেটা
I am for the petitioner. I have concluded my submission. Senior standing counsel will.
I'll reply to Mr. Shahara.
Yes.
No, my lord, in this matter, my lord, the show cause and suspension are under challenge, which departmentally, my lord, went up to the appeal stage, and the appeal was rejected as against the petitioner, and that is also under challenge. Now, my lord, the allegations against the petitioner are twofold. One is catering to ghost ration cards which were non-existent from the year 2015 to 2022. And
Yes.
second is discrepancy in the physical stock when a physical verification was held at the godown of the petitioner. These are the majorly two allegations against the petitioner. Now, my lord, if I have understood correctly, the thrust of my learned senior's argument for the petitioner is that vagueness in the show cause, vagueness in the order, it was not the fault of the petitioner. The department should have seen whether there were ghost ration cards or not. And as far as the short supply, short stock in his godown, he says that the distributor had given me less amount. That is why the stock was found to be less. Now, my lord, serving both the purposes of my argument as well as recapitulation, since my learned senior is not arguing today, if your lordship kindly start from the show cause at page 33.
Yes.
Show cause. So and so, kindly take the second paragraph onwards. An inquiry team visited the district on 2nd November 2023 and 3rd November 23 and conducted physical inquiry by meeting the beneficiaries, complainant and the FPS owner and the block officials. As per the detailed finding, most of the families the team met did not recognize many deactivated beneficiaries who were there in the family as per the database. Whereas it also appears that many cards were created through Form 4 about which actual families were not aware. And whereas it appears that the families never received these physical cards as well as the allotted food grains. And whereas from the findings of the physical inquiry, it appears that the FPS dealer does not perform Duare ration regularly. It appears that the said FPS dealer has violated para 19A of the WBPDS 2020-13. Whereas it appears that another report based on the inquiry made by the area inspector Kaliachak 3 block, it appears that the family members did not recognize many of the deactivated beneficiaries who were there in the family as per the database. Whereas it appears that the dealer has committed an offense of black marketing or misappropriation or siphoning of huge quantity of food grains meant for public distribution. Hence, the said dealer is hereby directed to show cause in writing within 7 days so and so. Why suitable action should not be taken under 24A1 and 24A2. So these are the allegations against the petitioner. Now your lordships will find his reply, short reply at page 35. I have begun. Can you take the second paragraph onwards? As per the report from your letter, it is claimed that most of the families did not recognize many deactivated beneficiaries who were there in the family. But in registering new card, dealers do not play any role and it is fully controlled by the department itself. So I am not able to say anything regarding these irregularities. As I mentioned earlier, that in issuing new cards, department plays a vital role and not the dealer. So I am unaware of the fact. Receiving physical card is dependent on the department itself. I am also unaware of this fact. Why they did not receive physical cards? It is claimed that there is irregularity in dual ration. I would like to say that there are no irregularities, but sometimes, kindly marks, my lord, sometimes it is not possible because of some personal physical problem issues, and I apologize for that. Therefore, my lord, it is a sort of admission with explanation, if I may put it in this way.
Sometimes could not perform the.
It is not possible because of some physical problem issues, and I apologize for that. I will summarize it in a way to say that it's an admission with an explanation. He admits that there are because this relates to the
Yes.
fifth last paragraph of that page 33, the show cause I had shown. It is also claimed that black marketing of grains is happening, but this allegation is not true and does not have any evidence of this claim. This is also to apologize and beg pardon for it. I have mistakenly wrong anything in accordance with this context. Very well, a general apology. Now, the hearing takes place at page 36. Kindly turns over to 36. Kindly takes after the second answer. মহকুমা নিয়ামক মহকুমা নিয়ামক একে একে ৩২৩ জন কার্ড হোল্ডারের নাম ডিলারকে পড়ে শোনালেন। ডিলার রেশন গ্রাহকদের চিনতে পারছেন কিনা এবং ডিলারের হাতে সেই লিস্ট দেওয়া হয়। ডিলার কোনো ক্ষেত্রে রেশন গ্রাহকের পরিবারের প্রধানকে চিনতে পারলেও ৩২৩ জনের মধ্যে কোনো রেশন কার্ডকে হোল্ডারকে চিনতে পারেননি। দেন কাইন্ডলি টেক দ্য প্রশ্ন। আপনাকে প্রদত্ত লিস্টের কোনো ব্যক্তি তাদের পরিবারের লিস্টে অবস্থিত কার্ড হোল্ডারদের চিনতে পারছেন না এবং তারা সেই সমস্ত গ্রাহকদের রেশন কোনোদিন নেননি বলে দাবি করেছেন। এই ব্যাপারে আপনার কি বক্তব্য? দি আনসার ইজ তারা মিথ্যে কথা বলছে। দেন প্রশ্ন, ৩২৩ জন মিথ্যা বলছে? হ্যাঁ, সবাই মিথ্যা বলছে। দেন প্রশ্ন, এত কার্ড বেড়ে যাওয়ায় আপনার একবারও সন্দেহ হয়? আপনার সন্দেহ হওয়ার পর কি আপনি ইন্সপেক্টর সাহেবকে জানিয়েছেন? না, জানানোর প্রয়োজন মনে করিনি। These are the three questions which are relevant for our purpose. His কোনটা পুরোটা পড়বো? Then my lord, I'm indicated that kindly take page 37 also, my lord, while we are at it. Though, my lord, I am a bit loath to take your lordships through intricacies of fact. I am to show the procedure, whether the procedure has been appropriately followed or not, because your lordship is in judicial review. Anyway, my lord, kindly take the প্রশ্ন। কার্ড যখন কমে গেছিল তখন কি আপনি ইন্সপেক্টর সাহেবকে জানিয়েছিলেন? না, জানাইনি। ইপস স্লিপ ও ক্যাশ মেমো আছে? না। এই সময়কার সেলস রেজিস্টার এনেছেন? না। লাস্ট কবে কার সেল রেজিস্টার আছে আপনার কাছে? বাড়িতে খুঁজে দেখতে হবে। ৩২৩ জনের লিস্টের মধ্যে নাদিরা খাতুনের পরিবারের ২৭ জন রেশন গ্রাহক আপনি কাউকে চিনতে পারছেন না? না। ইপস চালুর আগে কিভাবে মাল দিতেন? ক্যাশ মেমো কপি আছে? অনেকদিন আগের কথা, কাগজ নাও থাকতে পারে। আপনার এই ব্যাপারে আপনার আর কিছু বলার আছে? আমি মাল ঠিক দিচ্ছি ও আমাকে বারবার হয়রান হতে হচ্ছে। Therefore, no cash register, no EPOS receipt, even the period prior to coming of EPOS machine, cash memo, he says it is old, I do not know. And one answer he says that last কবে সেল রেজিস্টার আপনার কাছে আছে? He says বাড়িতে খুঁজে দেখতে হবে। So sale register, he has no idea about that also. So on one hand, in the reply, he says that there is no evidence against me. On the other hand, when the documents are sought from him, none of the documents, he says, is with him, and he cannot produce a single document to substantiate that he is innocent. Though your lordship has marked in the reply, he said that there is no evidence against me for short supply. আমাকে একটু পাতাটা বলে দাও তাহলে কি এইটার পাতাটা বলে দাও এটাই P8 হ্যাঁ হ্যাঁ। কাগজ থেকে তো দেখছি then my lord kindly comes to page 41. This is the physical verification of storage godown of FPS of Asraful Islam, Gopalpur, Kaliachok. Now, my lord kindly takes the last three entries. 9.4. My lord has found
Yes.
last three entries. Just above the last three entries, total quantity of rice found in the godown excluding weight of gunny bags is 225.02 quintal. Now can you take the last line? Discrepancies found in case of rice 229.4 minus 225.02 quantity, that is 4.37 quintal found short in the godown. Therefore, in the physical verification, this is found short in the godown. On the left hand side, your lordship will find the signature of Ashraful. All physical stocks of PDS commodities at my godown has been verified and there is no other stock to be verified. And thereafter he puts his signature. So physical inspection carried out in his presence. Next kindly comes to the order. At page 46.
Yes.
Yes. On the complaint of Samuel Mia and others was received by the Food and Supplies Department, FPS owner Ashraful Islam of block so and so. Then kindly skips over one paragraph, third paragraph. Whereas as per detailed finding, most of the families and the teams met did not recognize many deactivated beneficiaries who were listed in the family as per the database inquiry report enclosed herewith. Then the same as in the show cause, kindly take the last three entries. Whereas as per another feedback obtained regarding 269 number of presently deactivated cards, it appears that the concerned family members did not recognize the deactivated card holders who were listed in the families as per the database and also never lifted food grains against those cards. Whereas it appears that the dealer has committed an offense of black marketing or misappropriation or siphoning of a huge quantity of food grains meant for public distribution. Whereas during another inquiry made by the area inspector FNS and Gajol along with the area sub-inspector Kaliachok on 25th June 2024, 4.37 quintal of rice were found short in the FPS godown of the licensee. Report enclosed. It appears that the dealer has committed an offense of black marketing or misappropriation or siphoning of quantity of food grain meant for public distribution. The said dealer is hereby directed to show cause in writing with 7 days of the date of receipt of so and so as to why suitable action will not be taken against him in terms of para so and so and so and so. I stand corrected, my lord. It is not the order, but it is another show cause.
Another show cause.
Including the new physical verification of shortage of 4.7 quintal. Now, I'm sorry, my lord, in my notes it is, I have noted it as an order. So I stand corrected, my lord. This is again replied to, my lord, at page 48.
Yes.
And your lordships will find, though I am placing it, my lord, there is no actual denial of both the allegations. Kindly, my lord, takes from para 1. So far as the allegation, I say that being an FPS owner, I have got no authority so far as the insertion or deletion of any ration card. It is being done either by the inspector concerned or by the data entry operator. I further that being an FPS owner, I have got no authority to access the system of official portal of Food and Supplies Department. In view of the above, I have no idea about the deactivated beneficiaries. Again, inform I have got no authority to enter, verify or approve any application for issuance of ration cards. It is the entire domain of the food officials and the DEO. So I denied the charges framed against me to create many cards through Form 4 about which actual families were not aware. I beg to submit that I performed the Duare ration scheme from the beginning as per the schedule cluster regularly till now. I am not responsible for non-receipt of physical ration cards. It is the full responsibility of the head of the family and other family members of the DRC holders. So I have delivered food grains accordingly. I say I cannot either activate or suspend or transfer any DRC. I have lifted and the subsidized food grains according to my tagged ration cards, and it is not within my knowledge which ration card is deactivated. I cannot do anything except to deliver ration cards to these beneficiaries after biometric Aadhaar authentication through EPOS machine. Again, I say that I cannot make any entry in Form 4. This is to be done by the food inspector or concerned DEO. As such, question of illegal lifting, of black marketing, misappropriation of a huge quantity of food grain does not arise to me. Then 5. Regarding shortage of food grains, found in my shop, I beg to submit that the concerned distributor deliver a less quantity of food grains to me in comparison to the stock of food grains as allotted in the EPOS machine time to time. In the government order of so and so dated so and so, it is clearly mentioned that the distributor shall always deliver food grains to the FPS dealer on net weight basis, that is excluding the tear of gunny bags, HDPE or PP bags. For that reason, the shortfall of 4.37 quintal of rice as detected on 25th June 2024. I should therefore beg your pardon to be let off for this time, and I assure that this kind of irregularities will never occur. This kind of irregularities will never occur in future, as the said fair price shop is the only source of income for me and so and so. Therefore, my lord, the shortfall is not denied, but the reason for shortfall is said to be carry forward from a short supply by the distributor. Though, my lord, contemporaneously there is no complaint against the distributor. He is today justifying by saying that the distributor has given me short amount. But when the distributor had given him the short amount, there was no contemporaneous complaint or information to us till the physical verification took place. And as far as Duare ration is concerned, in the earlier reply he had admitted. Now he has bettered his answer to say that there is no discrepancy at all. Now, my lord, another hearing is taken. That is at very next page, page 50. Page 50 my lord has taken. এটা কি সেম ওইটাই মনে হচ্ছে, একই তো মনে হচ্ছে।
This is same.
My lord, it is the new answers are starting from page 51 bottom. Last two in 51 bottom. Before that it is same.
Yes.
আপনার দোকানে যে অস্বাভাবিক রেশন কার্ড বৃদ্ধি পেয়েছে, I think বৃদ্ধি বানান is incorrect, spelling. বৃদ্ধি পেয়েছে সেই বিষয়ে আপনি এরিয়া প্রদর্শককে জানিয়েছিলেন? এই বিষয়ে আমার জানা ছিল না যে এটা এরিয়া প্রদর্শককে জানাতে হবে। গত 25/6/2024 তারিখে যখন পরিদর্শক মন্ডলী যখন আপনার দোকানে গিয়েছিল, তখন 4.37 কুইন্টাল চাল কম পায়, সে বিষয়ে আপনার কি বক্তব্য? হ্যাঁ, সেই সময় 4.37 কুইন্টাল চাল কম ছিল এবং এটা দীর্ঘদিন ধরে আমার বস্তার ওজন না পাওয়ার জন্য ওই কুইন্টাল চাল কম ছিল। আপনি যে দীর্ঘদিন ধরে বস্তার ওজনের কথা বলছেন সেটা কি আপনি লিখিতভাবে এরিয়া পরিদর্শককে জানিয়েছিলেন? না। আপনার কি আর কিছু বক্তব্য আছে? আমি সরকারি আদেশ অনুযায়ী সুষ্ঠুভাবে মালের পরিষেবা দিয়ে থাকি। আমি রেশন কার্ড দেখে মাল দিয়ে থাকি। সেখানে লোক চেনার ব্যাপারে আমার কাছে সরকারি কোনো আদেশ নেই। আমার বাড়িতে 93 বছরের অসুস্থ মা আছেন এবং ওনার দেখাশোনাও আমাকে করতে হয়, কিন্তু অকারণে আমাকে বারবার অফিসে হেনস্থা হতে হচ্ছে। আমার বিনীত এটাই নিবেদন, আমি যাতে সুষ্ঠুভাবে রেশন দোকান চালাতে পারি এবং আমার অসুস্থ বৃদ্ধা মাকে এরকম মানসিক যন্ত্রণা থেকে মুক্তি দিতে পারি, তার জন্য so and so. With deepest of respect, my lord, and sympathy, my lord, it is irrelevant to the show cause. Now, my lord, the order is passed. That is at page 53. Three. First three whereas is more or less same, my lord. I'm taking from the fourth whereas. Whereas many cards were created through Form 4 about which the actual families were not aware. These families never received these physical cards as well as allotted food grains. Whereas from the finding of physical inquiry, it was evident that the SPS dealer did not perform Duare ration regularly. It is to be signed by whom? Filed by whom? Find out. Whereas, as per another feedback obtained regarding 269 number of presently deactivated cards holders who were listed in the families as per the database and also never lifted the food grains against those cards. Whereas during another inquiry team made by the area inspector Kaliachok on so and so 4.37 quintal of rice were found short in the FPS godown of the license. A show cause notice has been served on so and so. Whereas the FPS submitted its reply to the aforementioned show cause notice on so and so. Whereas the FPS was further given opportunity to present its defense, was personally heard on July 12th. All these I have already placed separately, my lord. On the day of the hearing, its submissions were recorded and the submissions were made against the charges frame were properly noted. The licensee was unable to produce any document or provide any cogent explanation to prove that he had indeed distributed food grains against those presently deactivated cards to the concerned families. Under the above circumstances, it has been established that the dealer has committed an offense of misappropriation of huge quantity of food grains meant for public distribution against ration card issued from 2015 till 2022, which are currently deactivated. Therefore, a penalty of rupees 7,85,61,000 is hereby imposed upon the dealer. This is done in exercise of power conferred upon the undersigned in paragraph 24A2 of the West Bengal PDS control order. The penalty amount is to be deposited within 7 days of receipt. Now, my lord, from this an appeal is preferred, which is at page 55. Kindly turns over to the order of appeal. My lord, here also hearing is taken. The hearing, my lord, the recording, the transcript of the recording is at page 65. There also more or less the same story continues. No documents supplied. Kindly takes, my lord, page 65.
Yes.
Kindly takes from serial number 3. আপনার অভিযোগ সম্বন্ধে কিছু বলেন। 2020-তে রেশন কার্ড নিয়ে গন্ডগোল। সামায়ুনের কাকাতো ভাইকে আমি জিজ্ঞাসা করি আপনার পরিবারে এতজন সদস্য আছে, তারপর তিনি বলেন আমার কার্ড আছে, মাল দিতে হবে। আমি মাল দেওয়া সত্ত্বেও শুধুমাত্র প্রশ্ন করার জন্য আমাকে মারা হয়। তারপর থেকে বিভিন্ন অফিসাররা বিভিন্ন সময় আমার দোকানে ইনকোয়ারি করতে আসেন। আজও সেই অভিযোগের ভিত্তিতে আমাকে শুনানির জন্য ডাকা হয়েছে। 2015 থেকে 2020 সালে স্টক রেজিস্টার আপনি দেখাতে পারবেন? এই সময় আমি বলতে পারছি না আমার কাছে আছে কিনা। আমার কাছে 2024 সালের আছে। আপনি এত লোক কোথা থেকে এলো আপনি কাউকে জানিয়েছিলেন? আমার কাউকে জানানো হয়নি। আমার 2020 সালে নজরে এলো। আমি বুঝতে পারিনি কবে থেকে আমার রেশন কার্ড বাড়তে শুরু করেছে। আপনি এইসব পরিবারের লোকগুলো চিনতেন? আমি প্রতিটা পরিবারের লোককে চিনতাম না, শুধুমাত্র প্রায় পরিবারের প্রধানদের চিনতাম। আপনার এর আগে 3বার হিয়ারিং হয়েছে, স্টক রেজিস্টার এবং সেল রেজিস্টার একবার কেন আনেননি? আজকে নিয়ে এসেছেন? আজকেও নিয়ে আসিনি, খুঁজে দেখতে হবে। মানে it's a bit of a curtailed version, but anyway, because after 6 it directly goes to 20. আমার অপোজিশনে ডিসপুট করতে পারতাম, হাফ দিয়েছে তো, আরো কিছু পাওয়া যেত। So the stock register and sale register has not come on that day also. As per control order, beneficiary list register maintain করতে হবে। আপনি কি করেননি? অনলাইনে আছে, আমি কোনো রেজিস্টার মেনটেন করিনি। আমি ব্লক অফিসে 2019 সালে পুরনো কার্ড রেজিস্টার জমা দিয়েছি। আপনি কোনো কিছুর প্রমাণ দিতে পারলেন না বা কোনো রেজিস্টারও দেখাতে পারলেন না। কোনো রেজিস্টার নেই, ইপস এ প্রমাণ আছে। আপনি ইপস থেকে প্রমাণ বের করে নিয়ে আসতে পারবেন? যদি অপশন থাকে তবে পারবো। আপনি আর কিছু বলবেন? আমি সবাইকে মাল দিয়েছি এবং ওরা সবাই মিথ্যে কথা বলছে। আমি জরিমানা মুকুব করার জন্য আবেদন করছি। Then the appellate authority's order, kindly takes page 68. My lord, 68 is more or less same. My lord, kindly turns over to 69. Reply, first paragraph, second paragraph records the reply, third paragraph records these oral submissions. Kindly takes from the fourth paragraph. Whereas the licensee was unable to produce any document or provide any cogent explanation to prove that he had indeed distributed food grains against those presently deactivated cards to the concerned families. Whereas under the above circumstances, it has been established that the dealer has committed the offense of misappropriation of huge quantity of food grains meant for public distribution against the ration card issued from 2015 onwards to 2022, which are currently deactivated. On so and so, kindly skips over that, kindly takes the last paragraph.
Yes.
The primary charge of the subdivisional controller, Malda Shodor, has brought against the MR dealer is that the licensee was unable to produce any document or provide any cogent explanation to prove that he had indeed distributed food grains against those presently deactivated cards to concerned families. Under the above circumstances, it has been established that the dealer has committed an offense of misappropriation and siphoning of huge quantity of food grains meant for public distribution against the ration cards issued from 2015 onwards until 2022, which are currently deactivated. After careful consideration of the above mentioned facts, it appears that the MR dealer is guilty of contravention of the provisions of the West Bengal Public Distribution System Control Order 2013. The subdivisional controller has every reason to take action against him as per the provisions of the Control Order of 2013. No satisfactory explanation of the above mentioned facts has been provided by the MR distributor. Therefore, since no fresh explanation has been provided, the order of the subdivisional controller is being upheld by the appellate authority. The fine is also upheld. And in last paragraph is non-submission of the above mentioned fine will attract further stringent action. Now, this further stringent action, your lordship will find at 71, the suspension order, which is also under challenge in this petition. Malad, stay of that suspension order was refused. Modification was also preferred, that was also refused. An appeal was preferred, that was also refused, rejected. Now, my lord, if your lordship kindly takes, well, I'll place the affidavit in opposition, but if your lordship kindly takes first a few paragraphs from the writ petition, 32 to 36, page 11, madam.
Yes.
The allegation against us. The vindictiveness of the SCFS will appear from the fact that the SCFS issued the order of suspension of the petitioner's dealership on 18 September 24, ignoring the order dated 17 September 24 of the first appellate authority, granting 10 days time to deposit the penalty amount. The petitioner was not given an opportunity to cross-examine the said 269 beneficiaries who have allegedly stated that they do not recognize the deactivated ration card holders and never lifted the food grains against those cards, and as such, the order of penalty on the basis of the statements of the said beneficiary is bad and liable to be set aside. The allegation of not producing any document or any cogent explanation regarding the distribution of food grains among the presently deactivated card does not and cannot arise, since the distribution by the petitioner has been made through EPOS machine upon biometric authentication of any of the family members, and as such, the allegation is bald and baseless, rather only to harass the petitioner. But just pausing here for a moment, your lordship will remember that even the EPOS details he had not been able to produce in either of the three hearings. 1035. It is denied that there was any shortage in the stock of rice as alleged in the show cause notice. Rather, the authorities have acted contrary to the statute by not making the payment of the entire stock of rice on 100% basis as provided in clause 23F of the 2013 control order, despite arrangement of sufficient laborers and payment of devices by the petitioner as provided in clause 19(9) of the 2013 control order. Again, pausing here for a moment, my lord. Their reply against the shortage was that the distributor had given me less supply. Now, my lord, a different case is being made out here. But then 36, this is the last paragraph I'll place from the writ petition. The authorities have failed to provide the basis and the calculation in respect of such a huge penalty and have imposed the same only to victimize the petitioner. So, my lord, these are the main allegations subject to correction by my learned friends against the authorities. Now, this has been dealt with, my lord. Kindly takes the affidavit in opposition. Kindly takes from paragraphs 22 to 26. First, my lord, kindly takes Q. Para Q. 5Q, I'm sorry. Well, that will be at page 9. Well, up to paragraph P is, well, what I have already placed. Q.
Yes.
Thus, it is stated that the petitioner has committed many irregularities, including black marketeering. The activities of the petitioner have impeded the smooth functioning of the public distribution system of the concerned area. In the year 2022, the petitioner paid a fine of rupees 20,000 for derailing the smooth implementation of the Duare Ration scheme in 2021 by not performing Duare Ration properly. Subsequently, several complaints were received against him for not performing the Duare Ration. Upon inspection, other findings like misappropriation of food grains, black marketing, taking no actions regarding unrecognized ration cards, misappropriating surplus ration received on account of fictional beneficiaries for 7 long years came into the light, for which the petitioner could not provide any satisfactory explanation. Therefore, the answering respondent rightly imposed a fine of rupees 7 crores 85 lakhs so and so. Now, my lord, kindly take paragraph 22. That will be page 22. 22 at 22.
Yes.
Kindly takes, my lord, from the last line of page 22. It is stated that, last line. It is stated that the respondent number 5 imposed the penalty amount of rupees 7 crores 85 lakhs as per clause 24A subclause 2 of the West Bengal Public Distribution System Order 2013. Now, it is pertinent to mention here that 24A3 empowers the answering respondents to suspend the license of the petitioner for contravention of clauses 24A1 and 2 for the second time. Thus, the baseless claim of vindictiveness is nothing more than a diversion from the petitioner's grave misconduct, which includes misappropriation of food grains intended for public distribution. 1023. But kindly takes the last 5 lines. It is stated that the petitioner was given enough opportunities to produce the records or accounts showing the issuance of food grains to those 269 beneficiaries. However, the petitioner repeatedly failed to provide such records or documents or sale or stock registers. This is in answer to that point that I have not been allowed to cross-examine all the 269. Question is whether opportunity was given to the petitioner or not. Ample opportunity. When the opportunity was given to the petitioner, he could not produce any documents.
Yes.
Then, my lord, paragraph 24. In 24, my lord, kindly turns over to the next. Kindly turns over to page 24 and takes from 6th line from the top of page 24.
Yes.
It is stated that as an FPS dealer, it is the obligation of the petitioner to maintain an up-to-date list of actual existing beneficiaries whom he caters to, which the petitioner in the instant case failed to do for a period of 8 long years. In the order to avoid prolixity, the answering respondents repeat and reiterate the contents of paragraph 13 of the instant affidavit. Then kindly take paragraph 25 after from the 3rd line. It is stated that the petitioner had a large amount of stock in his godown, and in the absence of a sufficient number of laborers despite notice, percentage payment like 10% was done in consultation with the petitioner in accordance with the mandate of the memo number so-and-so dated 18 May 2022. It is stated that as per the mandate of the memo dated 18 May 2022, half of the number of bags which were weighed was chosen by the petitioner and the remaining half was chosen by the inspection team. Based on the average weight found after 10% weighment of available stock weight per bag was 49.89 kg. After making calculations on the basis of 10% weighment, physical stock, a total shortage of 4.37 quintals of rice grains were found in the entire stock. The counting of bags was made very cautiously in the presence and with the consent of the petitioner. Physical verification was done in the best possible way on the basis of the percentage weight. Each and every weighment chart was countersigned by the petitioner. Therefore, contemporaneously, there was no allegation. As I have already indicated, in the petitioner's present, the petitioner's consent, the weighment has been made, and half of the bags has been chosen by the authorities, half of the bags has been chosen by the petitioner himself.
Yes.
Therefore, there is no question of conducting an inspection behind the back of the petitioner or without his knowledge. Then 26. 26 is reply to paragraph 36, where the allegation was that it is without any calculation of 7 crores 85 lakhs is without any basis. It is denied so and so. Kindly takes my lord from 1, 2, 3, 4, 5, 7th line of para 26. It is stated that.
Yes.
It is stated that Part 1 of Schedule B of the West Bengal PDS Order 2013 provides for the imposition of the following penalty, which is as follows. Offense of non-participation in doorstep delivery scheme framed under Clause 19A. Fine of minimum 1 lakh, which may be extended to a maximum of 2 lakh, which is penalty for the second time offense in contravention of the same provision. Since the petitioner was convicted of not performing the Duare ration in the year 2022 and a fine of rupees 20,000 was imposed upon him by an order dated 20th September 2022 issued by the respondent number 5. So making it the second offense.
Yes.
Then kindly turns over to the next page. Second bullet point. Commission of offense under subclause 2 of 24A. Fine of 1.5 times and a maximum of 3 times the economic cost of the food grains, and also a minimum fine of rupees 50,000 for an offense of black marketing or misappropriation or siphoning of food grains meant for the public distribution as a penalty. Though the basis of calculation has been specified as to the manner of the penalty imposed under the West Bengal PDS Control Order 2013 itself, but for more clarity, the basis of the determination of fine amount of the petitioner is annexed at R7. Now, kindly takes page 95 of the affidavit. I will place some other paragraphs, pages, but kindly take 95 first. Now, my lord, here your lordship will find the entire basis of the calculation has been given. Now, I am not taking your lordship box by box, page 95. Your lordship will kindly take the last box. Last row. That the total economic cost of the misappropriated food grains L plus M plus V plus W plus Z is so and so. 1.5 times of the economic cost of the food grains, misappropriated food grains is 7 lakhs 85,000, 7 crores 85 lakhs 11,000 and 44. To that 50,000 fine has been added, making it 7 crores 85 lakhs 61,000 and 44. Yes. So this is the amount of penalty, and the basis also we have given in text as well as in mathematical calculation for their kind perusal. Now, my lord, apart from this document, your lordship will also kindly take soft copy আছে তো soft copy আছে আমাকে পাঠিয়েছে রিতেশ Malad, your lordship will find first, Malad, kindly takes page 30. But this is the first report. Malad, your lordship may remember that in the show cause there was within bracket it was stated that the report is enclosed. In the show cause it was mentioned report enclosed. But there is a report into the complaint of the FPS owner Ashraful Islam on the basis of the complaint of Samayun Mia. But these are the inquiry reports. Complaint number 1 is duplicate and fake cards in the excess of population. This is the first page. Then kindly take 31. It is the continuation and the details of all the members which has been found to be the deactivated part. These are the family members. Most of the families we met did not recognize many deactivated beneficiaries who were there in the family as per the database. The list of such persons we spoke to is given below. These are the list of the members. Then complaint number 2 in the same page is the beneficiaries don't know about the existence of double cards. Then next page, page 32 is the third complaint. That cards to Bangladeshi people, Malad, I'm skipping this over, Malad, because this did not feature in the show cause itself. Then complaint number 4, that the commodities being given at a lower scale than prescribed government scales. Finding is that during the inquiry, we found that many of the beneficiaries were not aware of the prescribed government scale. However, on asking the total quantity received by them, we found it matched with the quantity ought to be received as per the current entitlement. So nothing was found against the petitioner. And received not being given, complaint number 5. On inquiry, the beneficiaries said that they got received, but here again, many of them seem to be least bothered and taking receipt from the dealer. We told them that they should insist on taking the receipt in future so that they are able to cross-check it. Then page 33, Duare ration not being done. Kindly see the finding under the box that the portal report shows that the dealer is doing Duare ration regularly. However, it appeared from the beneficiary statements that Duare ration is not done regularly, though on the day of inquiry, we found the dealer conducting deer camps. Then complaint number 7, amassing wealth, etc. my lord. Then my lord kindly takes page 34.
Yes.
My lord kindly takes the bottom of page 34, under the heading overall finding of the team, that according to the sample survey of the inquiry team, it appears that many cards were created through Form 4 about which actual families were not aware. My lord, just pausing here for a moment, my lord. Form 4 is to be submitted by the head of the families. But the families in their deposition and the inquiry, it is coming out repeatedly that they are not aware of creation of these cards.
Yes.
In his deposition, he has said that everyone is lying. Though, my lord, if your lordship looks at it from the perspective of the authorities, where the version of the beneficiaries has been taken and the version of the dealer has been taken, almost 270 persons have deposed in a particular manner, and 1% has deposed in a particular manner. My lord, the authorities' belief has weighed in the favor of the 270 persons. Though, my lord, this 1%, my lord, it is 270 versions of the same thing versus 1% version of the same thing. So, my lord, the allegation as it appears here also is that the head of the families did not know that the cards are being increased. So, according to the sample survey of the inquiry team, it appears that many cards were created through Form 4 about which the families were not aware. It is also obvious to the team that these families never received these physical cards as well as the allotted food grains. It may be noted here the cards were distributed through Panchayat till July 2018. From the second half of 2018 till December 2019, cards were distributed through Inspector Office. From the inquiry, it can be inferred that these cards counted were increased to the benefit of the SPS dealer financially, and it could not have been possible without the connivance of the then block food officials. Then, my lord, the page 35 onwards is the statement taken, my lord, from all these families. But I am not placing it individually, but I'll, my lord, it was asked of, but I am placing one, that আপনার নাম মুস্তাক আসলাম, আপনার PHH ration card আছে, যার so and so number. Then he was asked whether Asif Iqbal, Gajali Khatun, so and so, so and so, so and so, having ration card number so and so, whether they are part of his family or not. And the answer is no. So in the name of the head of the family, all these ghost ration cards have been issued in the meantime between 2015 to 2022. And this was never reported by him before any of the authorities. And obviously, the commodities also did not reach these persons because these persons are non-existent. So your lordship can imagine, my lord, the kind of siphoning that happened for 7 years of 269 persons multiplied by the allotted goods, allotted commodities which never reach the beneficiaries. They are coming from the distributor to the dealer and getting black marketed somewhere else. And when the documents are sought for from this person, the person cannot give a single scrap of documents.
So the new card has to be created by the department.
My lord, here the allegation is Form 4.
Form 4.
But if your lordship takes Form 4 is to be submitted by the head of the family. Now the head of the families come and say that I have never given these forms and these persons are not my family members at all.
So how dealer can be attached in this?
No, my lord, the allegation
Dealer may have.
The allegation is that, my lord, in place of the head of the families, this particular dealer has submitted these forms. My lord, if your lordship takes 19, clause 19, subclause 12 of the 2013 control order, Well, if I may give a perspective to this issue, well, these ghost ration cards will neither inure to the benefit of the department nor inure to the benefit of the beneficiaries because they are not existent at all. Creation of these ghost ration cards can only inure to the benefit of either the distributor or the dealer.
Yes. Dealer or distributor
Therefore,
is the
Malad,
only beneficiaries.
Malad, when the families say that we have not submitted it, when the families say that these people are not my family members at all, but the only rational explanation there can be is that the dealer was doing something to increase these ration cards to his own good. Now, my lord, this presumption can be rebutted by way of documents. Your lordship has found that at least 3 opportunities were given to him, but he could not produce a single document to rebut this allegation against him. But I was at clause 19, subclause 12. If your lordship kindly takes that, how convenient it is for the dealer to come and say that I have not maintained any register.
Your
Clause 19,
clause 19,
subclause 12. May I hand over?
No, I have the copy. Yes.
Maintenance and preservation of different registers. Every dealer should maintain proper books of accounts, including ration card register, daily stock register, daily sales register, indent register, non-trial register, register of blank cash memo book, inspection book, and complaint book of 200 pages each, serially numbered, and each other register as the director may prescribe. All such registers and books are to be duly certified by any official of the FNS department not below the rank of sub-inspector and shall be maintained and preserved at the shop premises as permanent records for a period of not less than 2 years from the date of closure of the registers so that they are readily available for inspection on demand. Duplicate carbon copies of so and so, the dealer shall maintain daily sales register, preferably as and when sale proceeds, but under no circumstances shall be allowed to fall arrear even for a day. Now, my lord, at the cost of repetition, my lord, when he was asked for these documents, he said that আপনি কোনো কিছু প্রমাণ দিতে পারলেন না বা কোনো রেজিস্টার দেখাতে পারলেন না, কোনো রেজিস্টার নেই, ইপোসে প্রমাণ আছে. But that this itself shows that he is masking something. And in another answer, yes, answer to 20, page 67. I had read it. I am reading it again, my lord. That আপনাকে এর আগেও 3-4 বার হিয়ারিং হয়েছে, স্টক রেজিস্টার এবং সেল রেজিস্টার একবারও কেন নিয়ে আসেননি? আজকে কি নিয়ে এসেছেন? আজকেও নিয়ে আসেনি, খুঁজে দেখতে হবে. Because if these registers come, the cat will be out of the bag. But since it is a hearing and not a cross-examination, I would have given a suggestion that you are not giving these documents because it will show that there is discrepancy in your actions. Then, my lord, another answer goes appropriately well, my lord, with this 1912. বলো না শুধু 24-এরটা আছে. My lord, that will be answer number. Yes, answer number 4 before the appellate authority, page 65. That, well, I'm reading it, my lord, for your page. I'm reading at page 65.
Yes.
Question number 4. 2025 to 2020 সালে স্টক রেজিস্টার আপনি দেখাতে পারবেন? এই সময় আমি বলতে পারবো না আমার কাছে আছে কিনা, আমার কাছে 2024 সালের আছে। The clause requires him to keep everything for 2 years. At least it should have been there from 2022. Not less than 2 years. Therefore, my lord, kindly see the impunity of the person. Not only increasing the ration cards, causing siphoning the estimated, it is like liquidated damages because the amount is prefixed. Causing loss of siphoning of 7 crores 85 lakhs, and not a single scrap of paper he can give in his defense. And he comes in the writ petition challenging and saying, I have not been given opportunity to cross-examine 269 persons. But if I may put it in this way, first you show your bona fide. First you show your stock register, sales register, ration card register. Thereafter, the question will arise that whether any prejudice has been caused by not cross-examining 270 persons who have deposed against you. And his answer is that everyone is lying, I'm right. 270 persons are lying, I am right. That is his consistent answer. But even if your lordship takes the reply, affidavit in reply, page 3, and it takes page 3, para E. Yes. Toward the middle of paragraph E, page 3, my lord. After a comma, I stated that the lordship found. I stated that I may recognize the head of the family but cannot recognize all the ration card holders. But I have supplied food grains to all the ration card holders by issuing cash memo and subsequently by issuing slips from EPOS. Since I cannot have any reason to doubt the authenticity, however, SCFS did not pass any order within the statutory period and thereby said proceeding stood lapsed. Then kindly takes same similar, kindly takes page 7, last 2, 3, 4, 5, 6, 7, last 7 lines. Page 7, last 7 lines. Yes. I say that I have stated in the course of hearing that cash memos are issued through EPOS machine against distribution of food grains to the beneficiaries, which is sufficient to prove the distribution of food grains. No, I am sorry. That is not the clause. The clause is not that you will substantiate the distribution only by showing an EPOS slip. You need to maintain the register which has been called from you. Your lordship, at the cost of repetition, your lordship is in judicial review. Your lordship is not in the appeal of the appeal. Yes. Your lordship will kindly see whether the procedure has been appropriately maintained or not. Your lordship will kindly see whether appropriate opportunity has been given to the person or not. In spite of that, if the person, just to mask his own discrepancy, he comes and says that I do not have documents, the matter ends there. Thereafter, the latches on in procedure cannot be discerned from that particular procedure which has been adopted. Because 3 hearings, 3 to 4, 3 plus 2 times he has given reply, 5 times opportunity has been given to the person to show a document in his support. No document regarding supply of food. No document has been. Document is the primary evidence. If it is oral version versus oral version, my lord, I ask this question to myself that am I that wrong to believe 270% as opposed to 1%? Now, kindly pardon me for putting in a question form, my lord, but this is the question which perhaps arose in the mind of the authorities. Yes. Now, my lord, to finish, my lord, kindly. Well, I am reminded to recapitulate that as far as the 4.37 quintal is concerned, there is no. Your Lordship, I have shown the replies. He has actually admitted that it was the distributor has given me less amount. But contemporaneously, he never complained to any authorities that the distributor is giving me less amount. Yes. Now, my lord, kindly take the provisions once, 19A. Capital A, my lord. Yes. Save as otherwise provided under any other provisions of this order for distribution of public distribution commodities to the ration card holder, the state government may frame scheme for delivery of public distribution commodities by the dealer to the ration card holders at his doorstep or in any other manner as may be specified in the scheme, and the dealer shall be duly bound to distribute the public distribution commodities in that manner on EPOS based authenticated transactions. Then 24A, 24 capital A. এখানে নেই তো in this bound book 24A is not there. The separate compilation we had handed over. Yes. Twenty-four A. Yes. Penalty for contravention of clause 19A or black marketing or misappropriation or siphoning off of food grain by the dealer. If a dealer or his agent or any other person acting in his behalf is found to have contravened the provisions of 19A, the licensing authority may, after giving an opportunity of being heard, impose penalty upon him as stipulated in Part 1 of Schedule B. If a dealer is found to have committed an offense of black marketing or misappropriation or siphoning of food grains meant for public distribution, the licensing authority may, after giving an opportunity of hearing, opportunity of being heard to him, impose penalty according to the gravity of the offense as stipulated in Part 1 of Schedule B. Then, sub clause 3 is the power of suspension, that in case of being convicted under 1 and 2, then the authority has the power to impose penalty as per Part 1 of Schedule B. Now, kindly take Part 1 of Schedule B. Hmm? Hmm. Hmm? 24. Malad has schedule. After few of the schedules, Malad, Schedule A and Schedule B are there. Huh? ওই বইটার কত তো জানি না may I find it out for your lordship? Yes. এটা দিন আমাকে
Page 148.
Now I'm giving the first page, but I'll rely on the next page. You know? 219. But kindly turns over to the next page. Serial number 4. Yes. Well, serial number 4 is committing an offense under subclause 2 of 24A. That is black marketing, siphoning, etc. Well, that kindly takes a fine of am I gonna 2 times such? Am I gonna 2 times such? But mine is 2 times. Your lordship's
1.5.
1.5. Fine of minimum fine of 1.5 times and maximum 3 times the economic cost of the food grains, and also a minimum fine of 50,000 for an offense of black marketing or misappropriation or siphoning of food grains meant for public distribution. This is what has been applied, and also what has been applied, my lord, is serial number 3. Offenses for not implementing Duare ration. Your lordship will find that for the second offense, the fine of minimum is 1 lakh, for which it may be extended up to 2 lakh in the second box, because this is second offense. First time 20,000 penalty was imposed in 2022. This is second offense. Mother, 2 more clauses. If you kindly take Mother clause 19 again. Page number 11. Page that will probably be page 12. Page 12. Okay. Yes. My lord, kindly take 19 subclause 4. The dealer shall maintain records or registers as specified by the state government from time to time. Then kindly takes 1911. 12 to 1911. The dealer shall be liable to do, I hope it is matching, Mullah.
Yes.
The dealer shall be liable to do the linking of Aadhaar with the ration card and make entries of mobile number in the EPOS device whenever required. Therefore, Mullah, linking is also, Mullah, the responsibility of the dealer. Therefore, there is no scope of escaping this. এখানে আসবে এখানে চেঞ্জ হয়ে গেছে and my lord, the pre-amended provision 19.3, because this is for a period of 2015 to 2022, there was an amendment in 2023. Can it, my lord, from the book takes the pre-amended version of 19 subclause 3. My lord,
yes.
Page 1.15.
19 subclause 3.
19 subclause 3. Registration and authentication of ration cards. On presentation of a card for registration, a dealer shall enter the particulars of the ration card in the ration card register, which is not there conveniently. Post a folio number in the ration card in accordance with the page number and serial number of entry of the ration card. detach the counterfoil from the card and return the ration card to its holder. The ration card having thus been registered, the dealer shall not refuse distribution of food grains to him or her from the following week. The dealer shall produce the detached counterfoil before the ration card issuing authority for authentication of the registration. All these provisions, my lord, have been bypassed by the particular dealer in giving an end to his ill motive of creating ghost ration cards. 217 number. Malad, those are তোমার কাছে আজকে reply দেবে? Malad, if they are not giving reply today, Malad, on the first of all, Malad, on the judicial review, I'll like to give a judgment. I'll give Mr. Shaharai the citation beforehand, Malad.
Yes.
And one is that, Malad, that this view taken by the authority with regard to Malad weighing in favor of 269 persons rather than his version who says that it is all false. They are all versions false, Malad. Malad, if two views are possible, Malad, how the authorities are supposed to act, Malad, on that, Malad, these two judgments I'll, before they start their reply, I'll give him, Malad.
Okay.
আগে দিয়ে দেবো তোমাকে দিও রাইট মেসেজ করলেই হতো আবার মেসেজ করবে আমি টেনে দেবো আর কি একটা when two views are possible.
30th of July at 2 p.m.
একটা হচ্ছে when two views are possible. কি করতে হবে?
Argument on behalf of the state authority.
Judicial scope of judicial.
Hard in part.
না আমি অন্য
Let the
perspective
matter be
দেখাচ্ছি।
fixed on 30th of
কাছে
July
একদিকে
2025
এই বেনিফিশিয়ারিদের ভার্সন আছে একদিকে ওর ভার্সন
for further argument on behalf of the state.
আমি এখন অথরিটি it is weighed in my favor যে ওরা যেটা এতগুলো লোক যেটা বলছে আমি একটা পসিবল ভিউ নিয়ে
No, this will be second item. One matter is fixed only. Otherwise, I have to go to August.
আগস্ট মাস গেটফুল মানে
Yes.
হার্ডিন তো আছে না 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 পিটিশনার
Call the list.
এই প্লিজ লর্ডশিপ
I appear for the state lordship. Before lordship takes up the matter, lordship, one small request. Lordship, by an inadvertent mistake, I find that in two of the last orders, with Sonal Sinha's name, though I appeared, some other name has been recorded. Shomallo Ganguly, order dated 23/4/2025.
I do not.
And order dated 2/7/2025. If that may be corrected by.
Instead of Munmun Ganguly, it is appears Shomallo.
Yes, Shomallo Ganguly.
Very good.
Two orders. One is 23/4 and one is 2nd May.
In the order dated 23rd April 2025 and 2nd July 2025, the representation of Miss Munmun Ganguly on behalf of the state was erroneously written as Miss Shomallo Ganguly. The same be corrected. Same be corrected through the department within a fortnight. Okay.
Grateful, Lordship.
Yes.
My lord, you kindly come to page 21, my lord.
For petition.
Well, this is the vacancy notice,
Page 21.
page 21 of the writ petition. Well, this is a vacancy notice for location Bamanagar, Charaktala bus stop. Now, my lord, pursuant to this notification, I uploaded my application along with the documents. The lordship will kindly come to page 31, that is deed of conveyance, my lord. That is relevant for this purpose. My lord. This deed of conveyance is, my lord, in favor of my father-in-law. The lordship here the Vikreta Kreta Sri Haradhan Mandal.
Yes.
Haradhan Mandal is my father-in-law, my lord. This is the property of my father-in-law, where I have constructed where the godown was constructed. Then, my lord, kindly come to page 26, my lord. Kindly come to earlier page 26. During the lifetime of my father obtained this permission from Gram Panchayat. Has also got, my lord, page 26.
Yes.
That is Bankim Chandra Gram Panchayat.
Okay.
This is the permission from the Gram Panchayat to construct the godown at the said plot.
Yes.
My lord, the sketch map is at page 37. This is a sketch map. According to this sketch map, which was approved by the Gram Panchayat, the construction was made. Then, my lord, will kindly come to page 38. This is the license which has been issued to me since I was found ineligible.
Okay.
Now, my lord, kindly come to page 41, my lord. Before I start functioning, my lord, a so-called notice was issued on 30 August 2024. Your lordship will find this license was issued on 14 August. Page 38 is 14th August, my lord. That is
14th August 2024.
14th August 2024. And this so-called notice was issued on 30th August 2024.
Yes.
My lord, I skip first paragraph. Second paragraph. Whereas you have submitted one conversion certificate from the block land and land reforms officer, Kagdi, BD such and such memo number, dated 26 December 2013. Lord, will kindly mark the date 26 December 2013 as supporting document of possession of land, mentioning plot number LR 1527, Khatiyan number LR 2627, JL number 35 in favor of Haradhan Mandal. My lord, will kindly mark Haradhan Mandal, my father-in-law, son of Asutosh Mandal, in order to obtain the SEMA dealership license to the office of the undersigned with your application dated 15 December 2022. And after that, one communication has been made from the Black Land and Land Reforms Officer Kagdi, Vidage Office Memo such and such dated 27 August 2024, wherein it is stated that no conversion certificate under section 4C of WBLR Act 1955 has been issued in favor of Haradhan Mandal, son of Asutosh Mandal, with a memo number such and such. Therefore, my lord, BLLRO has said that this certificate was not issued from his office. The certificate which I found from my father-in-law, who died in the meantime, that certificate is fake. Now, my lord, I'm coming to next paragraph, my lord. Whereas from the report submitted by the BLLRO such and such it is found, they had submitted a fabricated land conversion certificate of the proposed shop cum go down, bidder number such and such, to the competent authority. In this conversion certificate submitted from range, it was claimed that the nature of the land has been converted to Vastu. But till date, it appears the nature of land is still Barga, and thus recourse to fraudulent way to pass the eligibility criteria for obtaining this appellate dealership license. Therefore, it appears that you have obtained the appellate license in fraudulent manner and misled the authority. Well, that's why my license has been suspended. My lord, you kindly consider next page. Therefore, conceding the above with a provision of paragraph number 45(3), your lordship kindly mark paragraph 45(3) of West Bengal Targeted Public Issuance System, Maintenance and Control 2024. Now, new control order has been invoked. The license has been issued under 2013 control order. As amended, you are hereby directed to so called why no legal proceedings shall not be initiated against you for such deliberate action. Then, my lord, kindly come to next page. That you reply to so-called, my lord.
Yes.
In reference with your letter dated 30 August 2024, you hereby informed me that I have obtained a FPS license number such and such from your good office on 14 August 2024. But somehow certain dispute was made out in accordance with my papers and documents, which were I had submitted before your good office on earlier occasion. Out of it, one conversion certificate to be filed from my end, with a memo number such and such, that is, which was issued in favor of my father-in-law, since deceased, by BLL and LRO office Kagdi. And from here, categorically stated that the proposed land, which was subject matter of conversion certificate, is lying and situated within such and such place, is such and such measurement is there, madam. I most humbly inform that the process of such conversion application dated 24 December 2013 to be filed by my father-in-law and also obtaining certificate from that office by my father-in-law. Therefore, I have no personal knowledge in respect of that subject. I got married with Mahim Mandal in the year 2016. Therefore, the application of the conversion and certificate in this regard are to be completed before my marriage. At present, I being a housewife, most humbly, my lord, that is then, my lord. Then, my lord, page 44, my lord. The order, I am coming to third paragraph, my lord, because first paragraph is present. Whereas from the report submitted by the Block Land and Land Reforms Officer, Kagdeep, it is found that you have submitted a fabricated land conversion certificate of the proposed shop cum go down, bidder number such and such, to the competent authority. In this conversion certificate submitted from your end, it was claimed that the nature of the land has been converted to Vastu. But till date, it appears that the nature of the land is still Barga, and thus recourse to fraudulent way to pass the eligibility criteria for obtaining this appellate dealership license. Well, the same thing which was in the earlier order. And therefore, my lord, didn't reply. Well, last paragraph I'm reading, my lord. Whereas it appears that I have violated the terms and conditions of clause 15 IV. So, lord, will kindly mark last but one paragraph. Next page.
Yes.
15 IV of the FPS vacancy notice. Earlier, it has been claimed that I violated paragraph 45 of the control order. Now, in order, it says that I have violated condition of 15 IV of FPS vacancy notice. And therefore, my license is terminated. And that's why I am before your lordship, my lord. Now, my lord, kindly come to vacancy notice, that paragraph V, that is 15 IV at page 23. You got, my lord? 23, yes. Last but third, last but three, third or fourth, my lord. Any suppression of fact, oblique information or incorporation, providing of wrong information in the application form, or documents attached will be considered as a good and justifiable reason for disqualification. Your Lordship kindly mark my word. For disqualification for a candidate or rejection of application and taking appropriate legal action. This is only when the selection is in the process, not after the license has been issued. Because once the license is issued, that can be suspended or cancelled, whatever may be, under the Control Order 2024. Therefore, this order which says that I have violated the condition 15 IB, that cannot be sustained, my lord. My lord, I shall, I am fortified with a judgment also. I shall play for your lordship. Now, my lord, in spite of this, my lord, I have already made an application for conversion when I came to know that this is not a good document. Now, inspection was conducted and BLRO reported to ADM, but I have not yet got the conversion certificate. Your lordship knows, my lord, that after issuance of the license, if there is an application pending for conversion, I can submit it whenever I get it from the authority. Now, my lord, once the license is issued against a vacancy notification, your lordship will appreciate, my lord, that the applicant becomes the dealer, and any action against the dealer can be taken only upon violation of the provision of control order. Whereas in the order of termination, violation of control order has not been alleged. So-called notice, your lordship, find that has been issued alleging violation of paragraph 45(3) of the control order, but that has been given go by here. Because paragraph 45(3) empowers the licensing authority to put the license under suspension if found guilty of contravention of any provision of control order. And after recording the reason, he may impose fine or reduce volume of business according to gravity of offence. But may I place that paragraph 45(3)? The last year got my 2024 control order. So I have got my law, I have got it. My lord, kindly go on page 39, that is not. That is schedule. 45 is, my lord, at page 27, my lord.
Yes.
45(3). 43. That is, my lord, 45 starts from penal action against a dealer for contravention. 3 says, do not deliver the public.
No. 3 is the below.
Sorry, my lord. If the licensing authority on a complaint received against a dealer or suo moto is prima facie satisfied that the dealer is acting in such a manner which is prejudicial to the interest of the beneficiary tagged with his fair price shop, or may hamper smooth implementation of public issuance distribution, or may lead to law and order situation, he may immediately render the license under suspension, and after giving him an opportunity of being heard, if found guilty of any of the contraventions mentioned in these orders, he may, for reasons to be recorded in writing, impose punishment of either fine or reduce the volume of business according to the gravity of offence, or termination of his license as per offences specified in part 1 of Schedule C. Now, my lord, kindly come to part 1 of Schedule C. That is at page 39. But there is no 45(3). There is no penalty under clause 45(3). At least I could not get my right, I stand corrected if you. This is 45, 1 and 2 of paragraph sub 1. Then after it is 45, 3 to 11 of subclause 1. Then offense of not implementing the scheme under 17. Then offense of only issuing especially 45, 1 to 12. Then 46, 2. In any case, my lord, when the provision provides, thereafter what remains that if I am found guilty,
Yes.
of the offense committed, then according to the gravity offense, there can be punishment of either fine or reduction of the volume of business. Now, my lord will kindly consider that the reason only recorded is
Yes.
that I have submitted a fake certificate. Now, my lord, what could be the mens rea? Your lordship will appreciate, my lord, if I commit an offense, there should be some mens rea behind it. I was married in 2016. This certificate was obtained in 2013 by my father-in-law. Maybe it is a fake certificate. I should not use, had I have the knowledge that this certificate is fake. Because I can jolly well make an application for conversion. I may submit it after receipt of the license. There is a provision under control order. I was not required to submit that. So there was no mens rea in submitting that application. Now, my lord, your lordship knows that here, in the termination order itself, SCFS has not acted independently. My lord, kindly come to page 45 once again, my lord.
Yes.
Now, my lord, considering last paragraph, my lord. All the above facts and as per decision of government in food and supply department dated such and such, the license is hereby terminated by the licensing authority. The decision has to be taken by the sub-divisional controller after obtaining the after issuance of the license. He has issued the so-called notice. He has taken the hearing, but termination has been made under the dictate of the higher authority, without considering the fact that there was no mens rea in submitting that certificate. And my lord will be surprised to note that distribution of food gains is still made in my name. Someone else is making distribution of food gains in my name till date. And when your lordship has gone across on so many cases, my lord, in service matter, until charges are proved, no punishment can be imposed. Here, there is no allegation that I have not complied, I have violated any provision of the control order. Now, my lord, your lordship may say that since you have violated the condition of the vacancy notice that was alleged in the last paragraph, then in that event, my lord, I would like to place a judgment of this honorable court that has gone up to the Supreme Court, that once a letter of intent has been issued by the oil company, there were certain clauses to be complied with. Subsequently, it was found that there was some violation of the clause of the letter of intent. But in the meantime, the dealership agreement was executed. This court has held that for violation of the condition of letter of intent or of condition of the vacancy notice,
yes,
you cannot terminate the dealership agreement. My lord, I am relying upon that judgment, my lord. My lord, you kindly come to page 15, my lord. My lord, page 15, fourth line.
Yes.
My lord, there is no indication in the letter of termination that the petitioners have sold, assigned, mortgage, parted with, or transferred their interest in the distributorship or the right interest or benefit conferred on them after entering into an agreement. Accordingly, invocation of clause 21 is not a valid ground for termination of the distribution of the petitioner. Clause 23b mentions that distributors shall take active part in management and running of such and such, my lord, because they are the dealership agreement clause. Then, my lord, last paragraph, my lord. Clause 23c mentions that the distributor shall not enter into any agreement, contract, or understanding whereby the distributor may be controlled, carried out, financed by any other person. In the instant case, Hiralal Sarkar, the sole proprietor, changed the constitution of his business from proprietorship to partnership only after taking proper permission from the Indian Oil Corporation Limited. The alleged partnership agreement between Hiralal Sarkar and the private respondent was entered into on 26 December 2000, whereas the first dealership agreement was entered in between Hiralal Sarkar as the proprietor and IOCL on 20 March 2001. This agreement was, my lord, entered into before he was appointed as DG. And the second distributorship agreement was entered between Mrs. Bimla Gas Service for Partnership, firm of Hiralal Sarkar, and his wife Sumita Sarkar on 28 June 2012. Complaint was lodged by the private respondent 19 October 2012. Had the private respondent been genuinely aggrieved by any act of omission and or commission on the part of Hiralal Sarkar, he would have lodged a complaint long before. Lodging the complaint after a period of nearly 12 years from the date of execution of the alleged partnership deed cannot be made a ground for termination of distributorship. Now, my lord, this conversion in my case is also of 2013. And in 2024, BLR says that you are the fake certificate. IOCL contended that Hiralal Sarkar had changed the constitution of the business after execution of the dealership agreement. The fact that IOCL had permitted the proprietor Hiralal Sarkar to reconstitute his business and induct his wife as a partner indicates that IOCL did not have any objection in the reconstitution of the proprietary business to a partnership. There has not been any complaint from any consumer that the distributor was not providing service to them satisfactorily. Even after reconstitution of the business, the petitioner maintained services properly up to the satisfaction of the consumers. As IOCL had themselves allowed the petitioner number 3 to reconstitute his business, accordingly, they are stopped from raising the plea of reconstitution and further terminate the license of the petitioner on the said ground. An alleged private dispute in between one of the partners of a partnership business with a third party ought not be a ground for termination of distributorship of petitioner. No element of fraud and suppression of fact can be proved from the document. No, my lord, the question of recalling. Here, my lord, the letter of intent was recalled. Recalling the letter of intent also does not arise in the facts and circumstances of the instant case, in as much as the letter of intent had already been acted upon. My lord, the license has been issued, means that vacancy notice has been acted upon.
Yes.
And a proper distributorship agreement had been entered into between IOCL and partnership firm. Admission of the fact of entering into a partnership business with the respondent number 6 also does not have any consequence as the person making the complaint never appeared upon him. I am speaking here. Now, my lord, kindly come with next page 18. It is settled law that availability of alternative remedy is not an absolute bar to entertain a writ petition. In the instant case, the cause of action arose when the distributorship agreement was terminated by IOCL on 26 March 2014. The writ petition has been filed immediately thereafter. Admittedly, it took more than 4 years to consider said writ petition, hear out and decide the same. Adequate opportunity was given to private respondent to defend his case. The private respondent chose not to appear. Prior to passing the order of termination, and opportunity of hearing was given to all the parties. Even then, the private respondent chose to remain silent. Remanding the matter back to arbitration would not, in my opinion, serve the ends of justice. The same will again be sheer stage of them. In my considered opinion, remanding the matter for arbitration, with regard to the arbitration, there was a clause of arbitration. Then, my lord, next, I am coming, my lord, page 19, 1, 2, 3, 4th paragraph. In the instant case, there is no dispute between the parties to the contract. That is my IOCL and HON'BLE. A dispute has been sought to be raised by third party against one of the parties to the contract, the so-called aggrieved party. The respondent filed a title suit with civil court that is to dismiss, which indicates that he was not interested to proceed with his complaint. Delegating the petitioner to arbitration proceeding on such and such will be an empty formality. In the absence of any proved default on the part of the petitioners, the impugned order of termination of the distributor license of petitioner is bad and not sustainable in law. The same is hereby set aside. The respondent authority are directed to restore the distributorship license without any delay and preferably within a period of 6 months. In this case, what happened, my lord? The letter of intent holder executed a partnership deed with a third party. This was not permissible in the dealership agreement. Now, my lords, after dealership agreement, it came to the knowledge of the Intervenor that he had entered into a partnership agreement in violation of the terms of the letter of intent. Then they withdrew the letter of intent, causing termination of dealership agreement. That was challenged here, that whether a letter of intent which has been issued can be withdrawn after entering into the dealership agreement. Here is the case, my lord, that I have been granted license. And after grant of license, if there is a violation of any term provisions of the control order, there may be punishment according to the offense. Here, 45(3) was alleged to have offended of the control order. But when the final order was given, they have gone back to the vacancy notice, which has lost its force after issuance of the license. Now, my lord, second thing, my lord, though it is imperative to mention, my lord, but every charge, every offense, there should be mens rea. There cannot be any offense without any mens rea.
Yes.
Now, my lord, in this matter, I have got the document from my father-in-law who is now deceased. I have relied upon that document. After his demise, in that document has been said to be fake. Where is my mens rea? I ask myself, where is my mens rea? I could have submitted the document afterwards, after obtaining the license, because there is a provision for submitting the conversion certificate after the license is issued to me. There was no mens rea, and your lordship will kindly appreciate, there is the judgment. Your lordship has occasion to deal with these type of matters of mens rea and others. But for my satisfaction, I am placing one judgment, 2007-13 SCC. Yeah, 13. My lord, kindly. My lord, kindly see para 16. Para 16 at page 414, last but one page.
Yes.
It is by now well
Yes.
my lord. It is by now well established principle of law that for the offense and paragraph 16, my lord, that for the offense under section 409, 467 and 471, the existence of mens rea, bracket my lord, guilty mind, must be proved. It is on record that respondents 4 to 7 were working as STOs Deviculum. From the prosecution evidence, it appears that the conspiracy was hatched at such and such center. So far, with regard to the offense under section 467 IPC is concerned, there is no evidence to show that the applicants before us forged a document which purported to be valuable security. There is also no evidence that the appellants had knowledge of fact that the allotment letter was a forged letter. Again, for an offense under section 409, it must be proved that the person entrusted with the property or any dominion over property in his capacity as a public servant committed criminal breach of trust in respect of such property as defined in section 405 IPC. The evidence must show that he dishonestly misappropriated or converted to his own use that property, or dishonestly used or dispossessed that property in violation of any direction of law prescribing the mode in which trust is to be discharged. In the present case, there is no evidence that A4 to A7 dishonestly misappropriated or converted to their own use the amount of such and such. Therefore, my lord, in this case also, I have no guilt in mind. What I have submitted, a document which was available with me, which was obtained by father-in-law, who is now deceased. As soon as I have come to know that this document is forged, I have made an application for conversion, and that I have annexed with my afferent deployment. Now, my lord, until there is a mens rea, my lord, your lordship will appreciate, my lord, and there is no guilt in the mind, I cannot be prosecuted, my lord, only on the report of the BLRO that this is a fake document, which was not within my knowledge. Here, my lord, in this judgment, your lordship has seen that this was not within his knowledge, that the allotment letter was fake. Here also, conversion certificate is fake, was not within my knowledge. That's why I view. And now, my lord, I shall place one more judgment, my lord, wherein this honorable court has held that land classification is not a bar for grant of license. If that document is of not such a use that will enable any type of benefit to me, I would not have used it had it been in my knowledge. But since I have no guilt in the mind, I have got it and I have placed it. My lord will kindly see this judgment passed by Justice Vivek Chaudhary in a similar manner. My lord, kindly come last paragraph, last page, paragraph 26. The learned advocate for the petitioner has raised an objection that the land upon which the petitioner godown and shop room are situated is recorded as Bilan, agricultural land. No godown or office room can be constructed on agricultural land. The respondent number 6 failed to show that the land upon which the godown and shop room are situated was converted to Vastu land. It is needless to say that application for issue of license for appellate dealership is required to be filled in Form C. Paragraph 32 of the said form states that the petitioner is required to mention the character of the land, Vastu commercial agriculture. Thus, if the land on which godown and shop room are constructed is agricultural land, it does not disentitle an applicant from filing an application for dealership of fair price shop. It is for the Land and Land Reform Department to consider as to whether such construction violates the provision of Land Reforms Act or not. Only due to the construction of godown and office cum shop on the agricultural land of it does not mean that he will not be entitled to file any application for appellate dealership. My lord, there was a case where it was alleged that the respondent has got the license on the land which is agricultural land. It has been held that the license was rightly issued because it is not for the food department to see whether this land is agriculture or not.
Yes.
Well, I am not giving any other judgment, my lord, because Vimla gas service has been relied upon in another judgment also, that is of Rupa Chakravarti.
Yes.
Similar circumstances when there was an agreement before letter of intent, and that was not, the termination of dealership was not considered as appropriate, my lord. If your lordship desires, so my lord, I can give it, but I believe that it will just.
Okay.
Therefore, my lord, I formulate my point, my lord. The impugned order is bad on what ground? One, the order of termination has been issued under the dictate of higher authority. I have shown a lot. Next, the order of termination does not allege any violation of Control Order 2024, which is in vogue at present. Thirdly, my lord, rejection of dealership on the ground of the land which has not been converted. According to it, let it be assumed that it is not been converted. The dealership cannot be terminated because there is the scope of getting it converted subsequently. Even if I do not get it converted, according to your lordship has found the judgment of a coordinate bench, that it is not the authority of the food department to see whether this is converted or not. This is for the land and land food department whether any violation has been done or not. Therefore, my lord, in all the impugned orders should be set aside. My license should be issued. My lord, one more download, I have already stated that vacancy notice has lost its force upon issuance of the license. Therefore, no order can be passed.
Yes.
Except under the provisions of 2024 control order. These are my summary.
Okay.
I'm led by Ms. Sonal Sinha.
Yes.
Lordship, firstly, the two judgments which have been shown, I have been provided with only one. The first judgment I have not yet been provided with, therefore I cannot distinguish it right now. So probably I'll be taking one more day to distinguish and bring my judgments in response to the judgments shown by the petitioner. However, my basic points would be, like, since the petitioner talked about mens rea, I would say, what is mens rea and who understands the mens rea? The very fact, mens rea is intention, whether it's good intention, malafide or bona fide. I would say that the very fact that the petitioner suppressed and did not admit or declare that there was no conversion certificate or the land was not converted, that itself proves that the mens rea was not a right mens rea. Because what is the mens rea? What is the purpose? Purpose is to just get the license. Just hoodwink the authorities and get the license. So mens rea is nothing but hoodwinking here. Second point, Lordship, I'll elaborate on these points on the next day because today, as I said. Second point will be law and order. The petitioner was saying that unless there is a law and order problem, we could not have acted upon it. If Lordship will come to our report, then Lordship will find that we had received a complaint from the local people, based on which we had applied. Otherwise, there was no reason for us also to verify. There was a complaint which we had got from the local people. I will, yes, paragraph 8 of our report, Lordship, page 4.
Yes.
Subsequently, a mass petition, this is immediately after license was granted and people came to know, subsequently a mass petition / complaint was submitted by the villagers of Bamunagor Moza against Srimati Mamuni Maiti Mondol to the office of the Subdivisional Controller, Food and Supplies, Kakdi, alleging that Srimati Mamuni Maiti Mondol has constructed a godown on Borga land on such and such date. After receiving such petition complaint, the Subdivisional Controller issued a letter to the BL and LRO. So therefore, a complaint was received. We could not have ignored that complaint in total because a license, a vacancy notification is like the terms of a contract. Before I get into the contract in the first place, I am laying down my terms and conditions. And as the executor of the contract, terms of the contract, I am free. I mean, what are the terms that I need, keeping in mind public welfare? So once I have got the complaint from public, therefore, obviously, I will verify. Thirdly, I would like to address, he is saying that once the notification, once the license is issued, the vacancy notice loses its force. I ask myself, what happens in case of the license being issued completely under suppression of facts, misrepresentation? Then does that license still forcefully should continue just for the benefit of the petitioner and set a wrong example to everybody else so that from next time everybody can put up fake documents and get their licenses? Or should it be considered as something which has been, which is void ab initio? It is absolutely void ab initio.
Yes.
Next, Lordship. Since I don't have that judgment, I could not distinguish it right now. But whatever little bit I could understand is that he talks about 45(3) conditions for termination. না ফার্স্ট যেটা দেখালেন আপনি তো দুটোই দেখালেন বোধহয়, যেটা আপনি বললেন আর কপি নেই, রিপোর্টেড জাজমেন্ট, এইটা ওকে মেইনস্ট্রিম, ঠিক আছে, I will have to just distinguish. Now termination, now he had also another thing he had said that 2013 that certificate was issued. It was with her father-in-law and she did not know about this. Now when you're applying, I ask myself that if I'm applying for something, then I cannot just take my father-in-law's documents without verifying the authenticity of it, just go apply. By human error, I am granted a license, taken for considering that the license was erroneous, whatever it may be. By human error, I'm granted a license. And then I again come back and fight for that license. The very basis of that license was falsification, forgery. I will also bring to Lordship's notice their exception to our report. Page 4. Exception, their exception that they have filed to our report, Lordship.
Yes.
4. Paragraph 6, which continues to page 4. Then, Lordship, from the top, it will be 1, 2, 3, 4, 5. The 6th line, it is denied, where they are denying. It is denied that the Block Land and Land Reforms Officer Kakdeep could have reported that no conversion certificate was ever issued in favor of the petitioner's father-in-law on 22nd December 2013 as alleged. Could have issued. We are showing the certificate of the officer. We are still being challenged that now they will say that even the BL and LRO could not say whether it was converted or not converted. It is only the petitioner who can say whatever the petitioner wants to. Then towards the end, again, it is denied that the BL and LRO had issued the memo dated 27th August 2024. We have annexed the memo. On the basis of what are they denying? This is kind of a, I don't care. If I have got the license, I must retain the license, no matter what. Then paragraph 7, I say that merely by alleging that I have submitted a false or fabricated document without proving any dishonest intention or mens rea, no punishment can be imposed upon me by terminating my dealership. The first thing here is that what is the intention? The intention is to get the license. The intention is to get the license. For anybody who will, I just make a, before, as I said, I will take one more day, but I just draw a comparison, Lordship. I'm just asking myself. A medical student submits forged certificates, becomes a doctor. Tomorrow he is caught and his license is cancelled. Then can I say that no, once I've got my license, I still have to practice as a doctor. The forgery doesn't count. In this case, I say that the license itself is void ab initio because it is based on a wrong submission.
So why you mention the provisions of the vacancy notification? If you
We also have, yes, we have also mentioned provisions of the vacancy notification based on, kindly come to the vacancy notification, Lordship, which is with our report, page 10.
Yes.
15.4, where we say any suppression of fact or information or incorporation, providing of wrong information in the application form or attached documents will be considered as a good and justifiable reason for disqualification for a candidate or rejection of application and taking appropriate legal action. Appropriate legal action also includes, in my humble submission, termination if you have got the license like this.
No, you can cancel the candidature altogether.
But
during the vacancy notification is the provisions you have to follow at the time of making
correct,
selection.
Lordship, correct. That is why at the very
But
outset,
there is specific provision in the control order. You can take recourse that.
At the very onset, that is why I said, we got the papers. It was definitely fault of one or two erroneous officers who overlooked that, who did not cross-check. Everything was found perfect. License was granted. We received complaint from the local villagers. When we get that complaint, to cross-check, we send the ask the BL and LRO to submit us a report. BL and LRO submits the report. We find that yes, there was suppression of fact. Instantly, we give a show cause notice. The petitioner comes and says that it belongs to my father-in-law, so I was not aware, and the rest follows.
So the order should be according to the control order for termination of a licensee, not a candidate. He is not a candidate. She is not a candidate now. She is a licensee now under holding the license from the government. There are provisions
That
how
is
the
where, that is where we would also like to see if we get any judgments where we see that if that license itself was obtained and if we consider it as void ab initio, then what happens?
Okay.
My lord will kindly come recollect my lord's proposed notice has been issued for violation of the control order, not for violation of the vacancy notice.
Yes. But Mr.
And we
Akbar,
need to
how one can be allowed to a license over a Borgaland?
My lord, this is the task of the Block Land and Land Reforms Officer.
Forget about the task. Whether you can, one person can be allowed to construct
There
a building over a
several
Borgaland.
judgments that there are different authorities to look after their own job.
Maybe the agriculture land can be converted, but the land which cannot be converted at all, according to the provisions of law.
Well, in this case, if your lordship so we have already applied, and Varga is going to be deleted within 4 or 5 days, I have been told. Already all report have been gone. It is lying with the ADM and it is just to be signed by. It is going to be deleted.
Very good.
It is no Varga, my lord, actually.
If it is agriculture, then I can understand. But if it is a Borga land, yes, please take down. So when
1 week, Lordship, just getting judgment, and Miss Sona Sinha is not here. She is going to be the main. Maybe next week,
next week not possible.
2 weeks,
5th of August,
5th of
5th of August, 2 p.m. Please take down. Argument on behalf of the petitioner concludes. Argument on behalf of full stop. Argument on behalf of the state continues. Let the matter appear in the list on 5th of August 2025 at 2 p.m.
Biplab, my lord.
grateful, Lordship.
The paying is hard in part, my lord.
Yes.
Now, Kumar, I am applying for the applicant in CAN 1.
Very good.
But I am filing my affidavit in reply to the affidavit in opposition, my lord.
Mr. Amritalal Chatterjee appearing for the state. Mr. Bandyopadhyay, you are for the petition.
For the petition. The problem is, my lord, I initially filed an application prior to summer vacations that I challenged my termination. My lord, in the resultant vacancy, already the process has been initiated to fill up the vacancy. My lord, I filed an interlocutory application, my lord, praying for an interim order, my lord, that let them proceed with the vacancy but not to give any license. My lord, when this application was being considered, Mr. Chatterjee submitted that let the
License
lead
has already been granted.
No, it has not yet been granted. It is still under process. He submitted that let the read be heard out finally.
Yes.
Now the problem I am facing, my lord, you also had fixed this matter, my lord, twice at 2 p.m. Unfortunately, because of the other matters, my lord, it cannot be taken up today. But in the meantime, they are proceeding with the vacancy. Now, if any, my lord, third party, my lord, any license is granted, my lord, it will create havoc because my read may become infructuous. That's this CAN 2. It is still pending. Let them process, my lord, but not to finalize. Otherwise, my read will be infructuous. I am ready to do, my lord, with the read petition itself.
Now, who is intending intervenor?
They are the set up by the subdivisional controller against whom the allegations have been made. He is the person, my lord, who hold
My
the ration
affidavit in
cards.
reply will be taken on record, my lord.
Who hold the ration, in whose paper the ration cards have been temporarily tagged. He has no locus, my lord,
No, my lord, may I?
Affidavit in reply.
Affidavit in reply, they have filed an opposition, my lord. To that, I am filing my reply, my lord. They have filed an opposition to my application of addition of party, my lord. And my lord, state has also filed a report in my application, my lord. To that, my lord, there was no order, but I have prepared an exception, my lord. Let that be also taken on record, my lord.
Where is the state?
Chatterjee was there. He has no locus, my lord. I can
may I be allowed to move?
my lord. This is an addition of party order 1 rule 10. But he has no locus. But on my terminations, my ration cards have been temporarily tagged with him. My lord, he made allegations that I disturbed his, my lord, functioning. That do not constitute any ground for being added in my writ petitions. ওই তো তার সঙ্গে তাহলে ওকে Who is he?
My lord, may kindly take up the report of the state once. The state has filed a report in the with regard to my application, my lord. Can one state has filed a report? My lord, may kindly take up that report. I have filed an exception to that report also.
Petitioner সঙ্গে tag হয়েছে কি বলছো তুমি? এই তো 5 application. What is the application?
My lord, will find the caption as submission of short note related to Can 1 of 2025 arising out of. My lord has taken. My lord has got.
Yes.
It. My lord will kindly comes to page number 2, paragraph number I.
Yes.
On 17/12/2024, Ashim Kumar Chatterjee, my lord, I am the petitioner, the Can 1 applicant before your lordship, my lord. FPS dealer under Bharatpur 1 block, that is the petitioner, went to distribute FPS commodities as per government norms, where the writ petitioner, my learned friend's client, my lord, my learned senior friend's client, my lord, where the writ petitioner, along with others, physically assaulted the petitioner, for which the petitioner had also been admitted in the Kandi subdivisional hospital and further shifted to Katwa. Nupur Chatterjee, wife of the petitioner, here the petitioner means my lord, myself, my lord, but petitioner lodged an FIR against the writ petitioner and others at Bharatpur police station, white case number so and so. So, my lord, the subdivisional controller also affirms the fact that the writ petitioner disturbed me while distributing the FPS articles. Now, my lord, I had made a representation that I have annexed with the application, my lord. Subdivisional controller is refusing to entertain the application. Now, my lord, tomorrow they are disturbing me to distribute the application. Now, my lord, tomorrow if I cannot distribute the food commodities, subdivisional controller will be the first one to take steps against me. And now, my subdivision controller is refusing to entertain my application, my lord. So, my lord, where will I go, my lord?
The new cause of action against the subdivisional controller.
But my lord, the subdivision controller is citing this writ petition because this writ petition
may cite anything, but there is a new cause of action against subdivisional controller by which you are aggrieved. But why you are here?
My lord, the subdivision controller is saying that
your hearing is not necessary in this matter. This is the purely matter of the petitioner. Why his license has been terminated? What is the grounds? You are no one here.
My lord, but
private between
but my lord, they are I have been tagged with their dealership. I have tagged with their dealership.
General grievances against the.
No, my lord, I have been tagged with their dealership, my lord, and they are coming up. They are coming up and disturbing me,
you have taken a proper steps, criminal action against them.
I have registered FIR, my lord.
Registered FIR. So if the subdivisional controller is not bothering you, not caring you, though you are you are catering the ration articles,
and my lord,
you have the
and subdivision controller only gave me the duty to distribute their ration articles because they are terminated now.
I understand.
So, my lord,
if subdivisional controller is not hearing you, you have the general cause of action.
My lord, I have a representation annexed with my application, my lord. Let that be considered by the subdivision controller, my lord. My grievance will be sorted out, my lord.
That cannot be passed in this matter. I am disposing of these applications by giving you liberty to approach.
My lord.
Okay. This is Can 1.
Can 1, my lord. My lord will be giving me liberty to approach for the subdivision controller himself.
Yes.
That will also serve my purpose. That will also serve my purpose.
Yes, Mr. Bandyopadhyay.
I was persuaded by their application, but I find that my ration cards have not been tagged with them. Somebody else's card have been tagged. BC Singhorai, another dealer. Nothing to do with this, my lord, my petition.
Whatever may be, if your ration card is tagged, that is altogether no issue in this petition.
Even then, that does give him any right, my lord, to be added in my petitions. But kindly take page 9. It appears that it has been he has been tagged with terminated dealer of BC Singhorai and others.
No, my lord, with that regard, I have made amendments in my application, my lord. My lord will kindly see.
Page 9.
Page 9.
Page 9 of their application.
BC Singhorai.
Yes, I am not BC Singhorai.
You are not BC Singhorai?
No, I am.
So, my lord will kindly comes to paragraph number 3 of my application. I have made amendments to that effect, my lord.
That is a wrong amendment.
No. So the petitioner here is an
His
emergency.
representation in 10 or page 10 also says BC Singh order.
No, my lord, I am in my application also I say that, but my lord, on the same date on which the petitioner was terminated, my lord, on the same date BC Singh order was also terminated, my lord. And my lord, both of them actually are creating the disturbance, my lord. And my lord, the subdivision controller has also admitted that, my lord, in his report, my lord.
And my
Okay,
decision,
please take down. I am disposing of this application
lord.
today.
My lord, my exception and my FDP reply will be kept on record, my lord.
Exception filed on behalf of the intending intervener be taken on record. Affidavit in reply filed on behalf of the same intending intervener is also taken on record. Can 1 of 2025. This is an application for addition of parties by one Asim Kumar Chatterjee.
My lord.
Asim Kumar Chatterjee. Full stop. It is the contention of the petitioner, intending intervener, that after termination of license of the present petitioner, he being the neighboring dealer was permitted by the concerned authority to distribute the ration article. Thereby, the DRCs of the present petitioners were tagged with his.
no, madam, my DRCs have not been tagged with him.
No. You see, this is the contention of the.
No, my lord, will kindly comes to my application, my lord.
Okay, just wait.
Yes.
DRCs of the petitioner were tagged with the intending intervener, with the PS of intending intervener. Full stop. He submits that while the intending intervener was distributing the ration articles.
My lord, my contention is paragraph number 4 of my application, my lord. Kindly seize, my lord. Paragraph number 4 of my application, my lord. 3 and 4.
The present petitioner and one BC Singharai, whose license was also terminated, has beaten him up, causing disruption of distribution of ration articles. Full stop. Consequent thereto, one FIR was lodged with on FIR being FIR number. My lord, FIR being police case number 341 of 2024, dated 17/12/2024, was lodged with Bharatnagar police station. Full stop. Again, police station against the present petitioner. It is the
Bharatpur police station.
Bharatnagar or
Bharatpur.
Bharatpur police station against the present petitioner. He further submits that the petitioner, the intending intervener, has made a representation to the concerned respondent authority regarding his grievances, but they were not heard in respect of their grievances. Hence, the petitioner, intending intervener, approached this court for necessary relief. Full stop. Having heard the learned counsel for the parties, also considering the report placed by the state authority in respect of Can 1 of 2025, it appears that the intending intervener was it was alleged that the DRCs of the petitioner was tagged with intending intervenor. Full stop. Report shows that FPS dealer of BC Singh Roy and others under Bharatpur Block 1 was tagged with the intending intervenor, being neighboring ration dealer. Full stop. The intending intervenor alleged to have been assaulted by the petitioner, for which the petitioner has approached a appropriate forum by lodging a complaint. The intending intervenor intends to include in this proceeding as a added respondent. Full stop. It appears that the instant writ petitioner had challenged his order of termination passed by the respondent authority. Full stop. The intended intervener had no occasion or issue to participate in the instant proceeding, as he has no reasons to demonstrate any merit in this matter. Full stop. The reasons for termination of license of the petitioner is the order an order thereof is the subject matter of the in the instant writ petition. Thus, I find no justification to allow the intending intervener to participate in the said hearing. Full stop. Under the above observation, the instant writ petition, instant can application being can 1 of 2025 be disposed of. Full stop. It is clarified that the petitioner is not remediless. Petitioner now. Intending intervener is not remediless. He has already approached appropriate forum for his alleged assault by the present petitioner. Moreover, if he made a representation to the authority concerned must have give a patient hearing to the petitioner, to the intending intervener, by and shall dispose of the representation according to law. Full stop. Next paragraph. Can 1 of 2025 is disposed of. Full stop. Can 2 of 2025. This is an application for appropriate order.
Yes, my lord.
None appears on behalf of the state respondent.
Vacancy notice at page 14. A.
Whether they have used any opposition against
No,
Can 2?
nothing, my lord.
The state
Page 14.
State respondent has also not used any affidavit against the Can 2 of 2025. Concerning the situation, let the matter be appear in the list on 22nd of July 2025 under the heading to be mentioned. On the date on the adjourned date, the application being Can 2 of 2025 could be heard along with the writ petition.
May it be at 12, my lord. Because now I am unable to reach my lord court by 10:30. Or I am this is because of the my lord road condition.
12:30 আছে 22 9. Okay, 12:30. At 12:30.
Item number 32. My lord, there was direction from the appeal court to file affidavit. So this matter went up to the appeal, and the appeal court has directed to file affidavit within 3 weeks. And therefore, my lord, let the 2 weeks have expired. Any date may be fixed for final hearing, my lord.
Which matter?
Item 32. Equal day.
Yes, what you want to
Any
say?
date, my lord, for hearing of matter.
It can be taken up tomorrow.
Affidavits have not yet been filed. And appeal court has directed to file affidavit within this week and next week for reply. Therefore, any date after 10 days, your lordship may fix for.
Let them file the affidavit within this week.
Peremptory direction ছিল।
There is peremptory direction.
Within this week.
Yes.
Let the week be over.
Then let it be go out of this. I shall mention my lord.
Yes, that would be better.
Right.
Otherwise, it would be appearing in the list. Who is appearing in this matter?
Mr. Sahara is on the side.
No, Mr. Sahara is for the respondent, private respondent.
My lord.
Now, who is the for the state?
For the state is my lord Suman.
Okay, so affidavit by Mr. Sahara. Affidavit by Mr. Sahara.
Mr. Sahara has already filed affidavit today. State will file.
State has to file.
State will file. Mr. Sahara has filed affidavit today. State is
Affidavit by this week.
by Friday.
By this week, means this Friday. Okay. Let the matter go out of the list. You mention it after completion of affidavit. Otherwise,
As well. My late.
Okay.
With
Please
liberty
take
to
down
mention.
item number 32. Item number 32. Let the matter on the submission of the learned counsel for the petitioner. On the submission of the learned counsel for the petitioner, let the matter go out of the list. Parties are at liberty to mention after completion of exchange of affidavit as directed by the Honorable Division Bench.
Diploma.